Hi, everybody. As Jeff said, my name is Peter Mollengarden. I'm an attorney here at K. Bender Rembaum. I've been practicing community association law pretty much my entire legal career, which began in 1984. So it's been a while, entering my 42nd year. I used to write developer documents or condominium HOA documents up in the Maryland area. I've done community association practice on the association side for the bulk of my career. The vast bulk of my career down here in South Florida. I'm a Florida Bar board certified specialist in condominium and plan unit development law. And we have, I believe it's 8 or 9 of us here at the firm right now. And that's probably enough about me. This is a long presentation. As Jeff mentioned, it's for homeowner association directors. This is not for condominium or cooperative association directors. It's for HOA homeowner association directors, and it's to get you guys certified. So one other thing is, since I am so technically proficient, not as we go through the outline, or as we go through the presentation, my able-bodied assistant, Jeff, he's going to be basically changing the slides. So if there's a little bit of glitch every now and then with a slide gets changed too quickly or too slowly, blame Jeff.
Yeah, that means I fell asleep at the wheel. So
his fault.
I'll do the best I can to keep up.
Anyway, so Jeff, I can start whenever you're ready to assist me.
And just quickly before I start the share, I see a couple of people asking in the chat here. If you join a little bit late, you'll be able to get the slides at the end after you fill out the required evaluation. We're going to place the evaluation in the chat, the same place where some of you are typing right now. We'll place that there a little bit later, and then you'll be able to fill it out. After you submit it, you'll get a link to download and save today's slides. The other question I see popping up in there quite a bit, you don't need to sign in. What happens every time you register, whenever you register for any of our classes, that information is tied together with the unique link Zoom sends you. So when you click the link to join, it links it together with the information you entered when you registered. So that is your sign, and there's nothing further for you to do. You're good to go, and you will be fine. And again, type your notes on the side. If you have a question for Peter a little bit later, we'll enable the Q&A for class-related questions if we have time a little bit later. And with that said, on to the presentation. And here is slide number 1.
And I guess I'll be a little bit remiss. My partners would be remiss if I didn't mention that K. Bender Rembaum, I'm in the Palm Beach Gardens office, as Jeff said. Our main office is in Pompano. This is pretty much all we do, is that we represent associations. We represent, I know it's over 1,000, I don't know what the number is, throughout South Florida and up into Orlando and on the West Coast. So representing associations is by far and away the focus of our firm. Okay, so why are we here? Chat for a couple hours, right? We are here today because within 90 days after being elected or appointed to the board of your HOA, the newly elected or appointed director must complete the educational curriculum administered by an education provider, such as myself, approved by the Department of Business and Professional Regulation. Now, this certification that you're going to get today, assuming you hang in there for the whole time, is valid for up to 4 years, okay? You must complete this certification at least every 4 years. So even if you stay on the board, unbroken for that 4-year term, you then have to take this course again, or the course that it is in 4 years from now at that time. Now, what we're covering today and what we're required to cover is financial literacy and transparency, record keeping, levying of fines, notice, and meetings requirements. Now, if a director does not timely fulfill their certification requirements, then that director is suspended, not permanently removed, but they're suspended from the board until he or she complies with that certification requirement. In the meantime, the board can temporarily fill that vacancy by appointing someone until the suspended person has fulfilled the requirements. These certificates that you're going to get today, the Secretary of the Association must maintain those in the association records for 5 years. So even if you're on the board for 3 days, The certificate is kept for 5 years. Now, one thing to keep in mind though, if a director inadvertently is not certified and doesn't have the written that certification, that doesn't negate actions done by the board, even though the director wasn't certified at that time. Okay. In addition to what we just talked about, having to take this course, if your association has fewer than 2,500 parcels, so that's lots, fewer than 2,500 lots, then the director, in addition to what we're doing today, has to complete 4 hours of continuing education annually. Okay. If the association has 2,500 or more lots, okay, then you have to complete 8 hours of continuing education every year. Okay, Chapter 720, which is the statute that runs associations. Real brief, we mentioned briefly, and Jeff did, HOA versus condo. Quickly to comparison, and I'm going to mention during the course of this thing some things that come up where there's differences between HOAs and condos. But just to begin with, just be aware that a homeowner association exists without any type of enabling legislation. In other words, you don't have to have a statute in order to be able to create an HOA. Condominiums, though, are creatures of statute. So without a condominium act, you cannot have a condominium because in condominiums, you are buying airspace. Okay. That's why high rises are condos. But HOAs, for years and years and years, there was no governing statute. In fact, the governing statute, the precursor to Chapter 720 came about, I think it was 92 or 93. So it's been about 30 years. It seems like a short time to me, because before that, again, there is no statute creating a homeowner association because it's a creature of common law. Now, in an HOA, the common areas are owned by the association. Common area, anything, roads, clubhouse, tennis courts, facilities, pool, whatever. In a condominium, though, what's sometimes referred to as common area is actually called common elements, and all the owners own those common elements in undivided shares. So a condo doesn't own its common element, it's owned by the owners, even though the association maintains it and administers it. An alteration, one more example, in a condo, it's statutorily governed how the association can alter or improve the common elements. In an HOA, it's pursuant to your documents. Frequently, that's the board. Sometimes it's an owner vote, depends, but it's not statutorily controlled. Okay, the next topic is what version of Chapter 720 applies, because currently there is Chapter 720, which is the Florida Homeowners Association Act. And we're going to talk about something now a little bit called about Kaufman language. And it gets a little bit complicated, so I'll try to make this as simple as possible. Basically, the substantive law in effect at the time that a contract is entered into and your documents are a contract, that's the law that governs that particular contract, or in your case, governs the association. So what happens when there's amendments to the law that occur after the association has been created? Well, whether those, this gets a little complicated, whether those substantive changes apply, because there's substantive changes to the law and there's procedural changes to the law. If it's a substantive change that changes substantive rights, generally speaking, it will not apply retroactively to an existing contract or to an existing declaration of covenants, unless the declaration was subjected to Chapter 720 as amended from time to time, which means that those future changes will be incorporated. But procedural changes in the law, like the requirements for notice and things like that, typically will apply retroactively, in other words, and will apply to existing associations as opposed to substantive changes. We'll talk about this further on into the presentation. We'll talk about some recent changes to Chapter 720. But long story short, generally speaking, without Kaufman language, and quite frankly, you see the Kaufman language much more in condominiums because they're a creature of statute, because they're subjected to Chapter 718 in order to create them. You see it occasionally in HOAs, but not that often. But in the absence of what we call Kaufman language, or subjecting the declaration to amendments in the statute from time to time, or as amended from time to time, generally speaking, those future substantive changes will not retroactively affect or impair an existing declaration of covenants. Okay, as I mentioned quickly, Procedural things means the means and methods for the application and enforcement of existing duties and rights. Substantive laws or substantive changes prescribes legal duties and rights. And once those rights are vested, due process prevents the legislature from retroactively abolishing them. The basis for this is that under the Florida Constitution, you can't impair an existing valid contract by a future law that arises after the contract's entered into. That's basically the gist of it. Now, the other statute, kind of forgotten sometimes, but it's still important, that governs or affects your association is Chapter 617, because almost every HOA, I think almost everyone I've ever seen anyway, is incorporated under the Florida Corporation Not-for-Profit Act, which is Chapter 617. Okay, you're also governed, as I mentioned, by Chapter 720, which is the Homeowners Association Act. In the event there's a conflict between Chapter 617 and Chapter 720, then the provisions of Chapter 720 will control, because that's more specific to an HOA, whereas Chapter 617 applies to not-for-profit corporations in general. But occasionally, and maybe more than occasionally, you'll have an issue that's not covered by Chapter 720, and there is no conflict per se, and one must look to Chapter 617 for the potential answer. All right. There's also conflicts with your own documents. And what we have here is an ad from like 1952, something Jeff was around for. So when there's a conflict between your declaration of covenants and restrictions, your articles of incorporation, and the bylaws, what controls? Generally speaking, we have this little dabble-do-ya. The declaration is a document of utmost or highest authority in the hierarchy. Then comes the articles of incorporation, which is sometimes a forgotten document. Then the bylaws, and even though it's not on this list, I'm going to throw in rules, okay? Because the rules are also enforceable, but they are the fourth document on the hierarchy. It doesn't mean they're not enforceable, it just means in the event of conflict, the other three will control. But in the event of conflict, it's dec, articles, and bylaws. And what I'll mention here real quickly is generally the law tries to read these documents together if possible, rather than saying, oh, there's a conflict. So in general, they will bend over backwards to read them together if possible. If not, then this is the hierarchy that controls.
I look pretty darn good having been around for that one back in the 50s, don't I?
Well, that's debatable. Okay. All right. So annual member meetings every year, you should or must have an annual members meeting. What does that mean? That's a meeting of the membership, not a board meeting, but a membership meeting. So you must hold your annual meeting annually, which makes sense, at a time, date, and place, which is provided pursuant to your bylaws, sometimes articles, but almost always it's in the bylaws. And then your election of directors must be held in conjunction with the annual meeting or as otherwise provided in the governing documents. But again, it's almost always pursuant to or in conjunction with your annual meeting. So that's the annual meeting. Now, sometimes associations will have additional membership meetings in addition to the annual meeting, not too frequently, but sometimes. Those are special membership meetings held for specific purposes. So again, when are those called? Well, when called by the board or when called by the request or petition of 10% of your voting interest, unless your documents provide for a different percentage of owners to petition or request a special members meeting. Now, unless your documents provide otherwise, the notice of an annual meeting is not required to include a description or purpose for which the meeting is called. However, I highly advise or highly recommend that you do that anyway, that you have an agenda and you have the purposes of your annual meeting in your notice. Special member meetings, though, you must include a description of the purpose or purposes for which the meeting is called, and the business at a special meeting is limited to those items that are on the agenda. What are the notice requirements? All right. First of all, you have to have the date, time, and location of the meeting. If the bylaws are silent or don't provide for the giving of notice of members of the of a membership meeting, then you must mail, deliver, or electronically transmit notice to all owners not less than 14 days before the meeting. And in order to evidence compliance with that, there must be an affidavit by the person who is providing that notice, signed and executed, notarized, and you have to keep that affidavit of notice with your official records. As I mentioned above, notice must be mailed or delivered to the address identified at the owner's mailing address in the official records of the association or electronically transmitted to the owner. Now, you can only send notice by electronic transmission, i.e. email or facsimile, these days it's usually email, to those owners who have consented in writing to receive their notice of meetings by electronic transmission. Now, once they give you that permission or they give you that notice, that can be revoked at any time by the owner. But as long as it's on the record, among the records, then you can send the notice by electronic transmission. Electronic notice requirements. The association may provide notice of any meeting by electronic transmission, again, email or fax, to any member who has consented in writing to receive notices in that manner and have provided their facsimile number or email address to the association for such purpose. Now, the email addresses and facsimile numbers provided by members to receive notice by electronic transmission, again, must be removed from the association records when they revoke their consent to receive notice in that manner. But the association is not liable for the inadvertent or erroneous disclosure of those addresses or fax numbers for receiving electronic transmission. Electronic transmission may not be used, though, as a method of giving notice for a meeting, which is called either in whole or in part for the purpose of recalling a director. So you cannot use electronic transmission for a meeting at which a board member is going to be up for recall. Although between you and I, generally speaking, recalls are usually done by written agreement, not at meetings. But if it is done at a meeting, the notice has to be mailed or delivered to the owners, not sent by electronic transmission. In addition to sending the notice to the owners, again, this is addition, not in lieu of, the association may, by rule, adopt the procedure for conspicuously posting and repeatedly broadcasting the notice of the meeting and the agenda on a closed-circuit cable TV system serving the association. In this instance, the notice and the agenda must be broadcast in a manner and for a sufficient continuous length of time so that an average reader can observe the notice and read and comprehend the entire content of the notice and the agenda. So it can't just be flashed up there for 2 seconds. Also, with respect to posting on the website, by January 1st of this year, the associations, the HOAs that had 100 or more lots were required to post the notice and the agenda of each scheduled members meeting at least 14 days before the meeting on their website. Okay. The notice must be posted in plain view on the homepage of the website or app. You have to have a downloadable app or a website, or on a separate subpage of the website or app labeled notices, which is conspicuously visible and linked from the homepage. The association must also post on its website or app any document to be considered and voted on by the members during the meeting, or any document listed on the meeting agenda at least 7 days before the meeting at which such document or information within a document will be considered. So if you're going to consider, let's say, an amendment to your documents, okay, either at your annual meeting or at a special members meeting, and you're also required to have a website because you're 100 or more parcels, then that document, in this case, the amendment or the amendments, must be posted on the website or the app at least 7 days before the meeting, in addition to sending them out.
I'm just going to reiterate, everybody, the chat is only for technical questions about Zoom not functioning properly. Hey, I can't hear Peter, something like that for me. Questions for the attorney for Peter will be a little bit later on when we enable the Q&A module. So please keep questions for Peter out of the chat, okay? Back to you, and let me change. There you go.
Okay. The members' right to participate, okay? All the owners, all the members have the right to attend the membership meetings and to speak at any meeting with reference to all items open for discussion and any items that are included on the agenda. And notwithstanding anything to the contrary in your documents, an owner has a right to speak on each item or each agenda item for at least 3 minutes. You can also adopt reasonable rules governing the frequency, duration, and manner of owner statements, which rules must be consistent with what I just mentioned above. I would recommend you adopt those rules and you make them reasonable. If you're having difficult meetings, then I really encourage you, advise you to adopt those rules. But even if your meetings are smooth and not problematic at this point, it's still good, I think, good to have reasonable rules governing the manner in which and the frequency of owner statements. Membership meetings must also be held at a location accessible to physically handicapped individuals if it is requested by a physically handicapped person who has a right to attend the meeting. So if any of your owners are disabled, are handicapped, and they request that a meeting be held in a handicap accessible location, then you must comply with that request. Finally, any owner may audio or video record any membership meeting, and the board may also adopt reasonable rules governing the recording of meetings. Although these days everyone pretty much uses their phone, but you can require that they announce that they're recording. You can require that they don't move around the room, they stay where they are. They don't bring in lights or things like that. But again, these days people use their phones and don't bring in, equipment like it did back in the old days. Quorum. What is a quorum? A quorum is the amount of members you need to be in attendance to have a valid meeting, okay, or to have a meeting. So for HOAs, this is an interesting point because the law used to be silent on this, and most documents said a quorum was a majority, back in the day. Then 720 came into being, and then 720 was amended, and pursuant to Chapter 720, unless a lower number is provided in the bylaws, 30% of the total voting interest of the association constitutes a quorum at a members' meeting. By the way, this is unique to HOAs. This is not in the condominium law, but in the HOA law, a quorum, again, is 30% being in attendance in person or by proxy, unless your bylaws provide for a lower, not higher number. Unless otherwise required by law or by your documents, decisions that require a vote of the membership must be made by the concurrence of at least a majority of the voting interest present in person or by proxy at a meeting in which a quorum has been attained. So with this type of language, okay, that means the vote to pass something or adopt something, unless your documents have a different requirement, usually a higher requirement, but in the absence of a different requirement, the vote is a majority of those present in person or by proxy. So actually, it's kind of a moving target. The vote will be greater or lesser depending upon how many people are in attendance in person or by proxy, provided that a quorum is obtained. So it's not a set target, but it's kind of a moving target depending on the attendance at the meeting. Proxies, and I am going to mention some difference here between condos and HOAs in a second, but unless otherwise provided in section 723.068 or in your governing documents, the members have the right to vote in person or by proxy. In order to be valid, a proxy must be dated, must have the date, time, and place of the meeting for which it was given, and it must be signed by the person authorized who executed the proxy. In other words, usually, sometimes your bylaws will provide who is authorized to sign a proxy for a particular lot. Usually it's the voting member of that lot. A proxy, but your bylaws may be silent, so you really have to check that out. A proxy is effective only for the specific meeting for which it was originally given. In any lawful adjournments, however, a proxy, automatically expires 90 days after the day of the meeting for which it was originally given. But a proxy has a 90-day life, okay? So in essence, if you call a meeting and you're trying to vote on something and you might have a quorum, but you don't think you have enough votes, or you don't have a quorum, that meeting can be adjourned, not finally adjourned, but continued to be reconvened at another time. And those proxies are good for 90 days. So when the meeting is reconvened, those proxies are still valid. So you can go out and solicit and get more proxies to try to adopt or pass whatever it is, an amendment or something else that you're trying to pass, because you had that 90-day window to continue your meeting to try to get more votes. Now, proxies are also revocable at any time by the person who executes it. So the lot owner who gives out the proxy, grants the proxy, he or she can revoke it whenever they want. Any proxy holder may appoint in writing a substitute proxy to act in his or her place if the original proxy provides such right to do so. So the right of substitution is, let's say that I gave a proxy to Jeff, okay? And Jeff is my proxy, but my proxy has a power of substitution, and Jeff can't make it that day because he's out doing something, he's doing another webinar, whatever. Jeff can then substitute somebody else to be the proxy because I granted him the power of substitution to substitute another proxy in case he could not fulfill his role as proxy. A copy of a proxy can be used of the original if it's a complete reproduction of an entire proxy. So the proxies that are actually at the meeting don't have to be the originals if they're complete copies or reproductions of the original, including the signature and the date, time, and place. And it must be dated. General versus limited. Okay. A general proxy is when I grant my proxy holder the authority to vote any way they want. Okay. Any way they can vote for me and they're able to use their own judgment to vote on whatever issue it is that they're voting on at that meeting. A limited proxy, though, is where on the face of the proxy, I am instructing or designating my proxy how to vote. So the proxy would say, for example, amendment to Article 12, Section 2 regarding restricting leasing to not more than once a year. Okay, yes or no. I will put on that proxy exactly how the proxy is going to be cast. So in that case, the proxy holder does not exercise their judgment. I am instructing them how to vote. So a limited proxy is kind of like the first cousin of an absentee ballot in that on the face of the proxy holder, is being told how to vote, and the limited proxy really acts in essence as a ballot, and the proxy holder is more just a warm body there. Interestingly, in condominiums, okay, under the Condominium Act, any substantive issue that you're voting on must be by limited proxy. You cannot use general proxies in a condominium to vote on substantive issues, like amendments or alterations or things like that. HOAs doesn't have that. However, your own documents, your articles or bylaws, most likely the bylaws, may provide that votes must be cast by limited proxy. But that is a case-by-case, community-by-community issue. It depends on what your documents say. All right, electronic voting, which is becoming more and more popular. In other words, voting online, where you sit home and you can just vote using your computer. So in order to establish internet-based online voting, it must be established by a board resolution adopted by the board at a meeting for which notice is given at least 14 days before the meeting by mail delivery, as we said before, by electronic transmission, and it must be conspicuously posted in the community at least 14 days in advance, and again, evidenced by affidavit that notice was properly provided. Now, what must that board resolution provide? Well, it must provide that members will receive notice of the opportunity to vote through an online voting system. It must establish reasonable procedures and deadlines for members to consent electronically or in writing to online voting. It must establish reasonable procedures and deadlines for members to opt out of the online voting after giving consent. The association may conduct membership voting through the online voting system if a member consents electronically or in writing to online voting, which is valid for that owner or for that member until the owner opts out, if he or she does opt out. An owner voting electronically is also counted as being in attendance at the meeting for purposes of counting toward a quorum. If you're using online voting, then the association must provide each owner with a method to authenticate the owner's identity, a method that is consistent with the association's election procedures and its bylaws. We'll get to that down the line here. A method to confirm at least 14 days before the voting deadline that the owner's electronic device can successfully communicate with the online system. The association must use an online system which is able to authenticate the owner's identity, authenticate the validity of each electronic vote to ensure the vote is not altered in transit, transmit a receipt to each owner who casts a vote online, permanently separate any authentication or identifying information from the electronic election ballot, rendering it impossible to tie an election ballot to an owner if the association's bylaws provide for secret balloting, and not all associations provide for that. We'll get to that a little later too. And store and keep electronic votes accessible to election officials for recount, inspection, and review purposes. So now we're going to talk about the specifics of elections. A vacancy on the board, remember, at every annual meeting is when you have your election. A vacancy on the board is caused by the expiration of a director's term must be filled by election. Okay, as opposed to a director whose term ends because of resignation or death or disqualification. If it ends because that term has expired, then it's filled by an election by the membership. The election must be held at or in conjunction with the annual meeting or as otherwise provided by your documents. Now, this is important. This third bullet point. Elections must be conducted in accordance with the procedures set forth in your governing documents. This is contrary to condominiums where their elections are governed pretty much entirely by statute. So the election procedure for a condominium is set forth in detail in Chapter 718, Florida statutes, and in the Florida Administrative Code. That is not the case with HOAs. There's some election stuff in the HOA law. We'll talk about that. But for the most part, the elections for each association, each HOA association is pursuant to your bylaws. Unless otherwise provided by your documents, a quorum of the members must be established in order to conduct an election and any other business conducted at the annual meeting. Now, again, I want to make a distinction here because for your condominium friends and for your condominium director friends, for condo elections, there is no quorum requirement for an election. 20% of the people voting constitutes a quorum in a condominium election. That is not the case for an HOA election unless your bylaws provide for that. For an HOA election, absent something in your bylaws, you do have to have a quorum to conduct the election, except for limited circumstances that we'll talk about. Unless otherwise provided in your documents, directors are elected by a plurality of the votes cast. So it's not, a majority of all, but it's who gets the most votes. Who's eligible to serve on the board? Okay. All of the members of the association are eligible unless otherwise disqualified, and we'll talk about that now. What could render someone disqualified, an owner disqualified to run? Okay. A person who is delinquent in the payment of any monetary obligation to the association, so that could be anything, assessment, a fine, whatever, on the day that he or she could last nominate himself or herself or be nominated for the board, cannot seek election. Now, what is that last day? That again depends upon your documents and how the nomination process is conducted. But basically, whatever that last day is, depending on what the nomination process is pursuant to your documents, on that day, he or she cannot be delinquent. Also, anyone convicted of a felony, either in Florida or in a U.S. district or territorial court, blah, 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 is not eligible to serve on the board unless their civil rights have been restored for at least 5 years as of the date on which he or she seeks election to the board. Finally, a person who has a pending, not convicted, but a pending criminal charge for forging a ballot or forging a ballot envelope or a voting certificate, felony theft or embezzlement offense involving the association's funds, tampering with physical evidence, which would be the destruction of or the refusal to allow timely inspection or copying of an official record in furtherance of a crime, obstruction of justice. For any of this kind of stuff, you are not you're not eligible. A member may nominate himself or herself as a candidate for the board at a meeting where the election is to be held. However, if the election process set forth in the governing documents allows a candidate to be nominated in advance of the meeting, the association is not required to allow nominations at the meeting. So, again, you're allowed to nominate yourself from the floor at a meeting unless your bylaws have a nomination procedure in which every owner is basically given the opportunity to nominate themselves in advance. The election day. Okay. What about election by acclamation? What does that mean? That means basically that you don't have a contested election. So an election is not required unless there's more candidates are nominated and vacancies exist. If an election is not required because there are either an equal or fewer number of qualified candidates than the vacancies to be filled, and if nominations from the floor are not required under your bylaws, then the qualified candidates commence service at the annual meeting, regardless of whether a quorum is attained. Remember we said before, you had to have a quorum at your annual meeting to have the election? Well, this is the exception, okay? If there's the same or fewer number of candidates and nominations from the floor are not required, then those candidates are automatically elected, even if there's not a quorum at the election annual meeting. Balloting. Again, members have the right to vote in person or by proxy unless otherwise provided in the governing documents. Huge distinction here between HOAs and condos. Just to throw this out for a second. In condominiums, you cannot vote by proxy in an election. Okay, it's prohibited. All voting is done by balloting. In an HOA, though, again, we're back to your bylaws. So persons are allowed to vote in an election in person or by proxy unless your governing documents have a procedure where there is no proxy voting. If the governing documents permit voting by secret absentee ballot, then in that case, the ballot must be placed in an inner envelope with no identifying markings and mailed or delivered to the association in an outer envelope, which identifies the name of the member, the lot that the ballot is cast for, and the signature of the member casting the ballot. That's similar to a condo style, but again, that's if your bylaws have secret absentee balloting. All ballots and proxies, if proxies are permitted, are tabulated on the day of the annual meeting. If more than one ballot is submitted for a lot, the ballots for that parcel are disqualified, and any vote by ballot received after the closing of the balloting is also not considered and not valid. And what is the term of the directors? Unless the bylaws provide otherwise, directors serve a one-year term. Now, some bylaws have staggered terms where they serve staggered two-year terms or staggered three-year terms. In that case, obviously, those provisions would control, but in the absence of that, directors serve a one-year term. Challenging an election. This is an interesting point. Any challenge to the election process must be commenced within 60 days after the election results are announced. It's a fairly short period of time. So let's say you mess everything up inadvertently and things aren't done correctly, but the 60 days go by, well, then it's too late to challenge what may have been insufficiencies or problems with the election process. So there's a 60-day window to challenge an election. Venue. In other words, where are these disputes considered? Any election dispute between a member and the association must be submitted to binding arbitration with the Florida Division of Condominiums, Timeshares, and Mobile Homes. This is one of the few times where the division has jurisdiction both over a condo matter and an HOA matter, and the election disputes are one of those, or filed with a court of competent jurisdiction. Election disputes submitted to binding arbitration with the division are conducted in a manner provided by 718.1255, again, which is a condominium statute, and the procedural rules adopted by the division. So here is one instance where there's some overlap with respect to dispute resolution for elections, where the division, which generally just deals with condos, in this case also deals with an HOA with election disputes. Officer elections. Okay. And I'll spend a moment or two here because sometimes there's some confusion regarding officers versus directors and how they're elected and what their terms are. Generally, and this is pursuant to your documents, but again, for the most part, officers are appointed or elected by the board immediately following the election of directors at the organizational meeting of the board. Directors may not vote by proxy or by secret ballot at board meetings, except, this is the exception, secret ballots can be used by the directors when they elect their officers, okay? And there is no prohibition against changing officers midterm. So generally speaking, under most bylaws, almost all of them, the officers serve at the pleasure, or maybe displeasure is a better word, of the board. So even though the board elects a president, vice president, secretary, treasurer for a term of, let's say, 1 year, in actuality, if for whatever reason the board wants to change the officer, they can change out who's president, change out who's vice president. That means that person is still on the board. They're still a director, but they can be taken out of their office and someone else put in that office. Directors, though, I'll stop here for a second. You cannot remove directors from the board. Okay, you cannot recall directors. You can remove someone from their office as president, but he or she stays on the board. The only way to recall a director, though, is through a vote of the membership, and we're going to talk about that later. Fraudulent election voting activities, and I expect no one listening to me will be engaged in any of this stuff, but we need to talk about it quickly anyway. A person who engages in the following acts of fraudulent election voting commits a first-degree misdemeanor, and these are some pretty serious stuff. Willfully and falsely swearing to or affirming an oath or affirmation, or willfully procuring another person to falsely swear to or affirm an oath or affirmation in connection with or arising out of voting activities, perpetuating or attempting to perpetuate or aiding in the perpetuation of fraud in connection with a vote cast or to be cast or attempted to be cast, preventing a member from voting as he or she intended by fraudulently changing or attempting to change their ballot, voting ballot envelope or that kind of stuff. And finally, menacing, threatening, or using bribery or any other corruption to attempt directly or indirectly to influence, deceive, or deter a member when the member is voting. So it's pretty serious stuff. All these things amount to fraudulent election voting activities. More of them. Giving or promising directly or indirectly anything of value to another member with the intent to buy their vote. Okay. This does not apply, though, to any food served, which is to be consumed at an election rally or meeting. So if you're going to have a vote for me and serve donuts, you're okay, as long as they're eating them at the rally or meeting, or to any item of nominal value, like a campaign pin or a button or something. Using or threatening to use directly or indirectly force, violence, or intimidation, or any tactic of coercion or intimidation, to compel someone how to vote. So again, things that hopefully that no one listening here will be involved with. Okay. Things that were enacted last year, but still pretty new, still pretty fresh. Each of these activities constitute a first-degree misdemeanor. Knowingly aiding, abetting, or advising a person in the commission of a fraudulent election voting activity, agreeing, conspiring, combining, or confederating with at least one other person to commit a fraudulent election voting activity, or having knowledge of a fraudulent election activity and giving aid to the offender with the intent that the offender to avoid or escape detection or arrest. Now, as I mentioned before, sometimes you'll have vacancies on the board not caused by the expiration of a term, caused by, before the term expires. Usually death, resignation, things like that. How are those vacancies handled? Well, unless otherwise provided by your bylaws. Okay, so got to check out your bylaws. Any vacancy occurring on the board before the expiration of a term, not including recall, may be filled by an affirmative vote of the majority of the remaining directors, even if there's only one remaining director. Okay. In the alternative, rather than the board appointing those replacements, the board can hold an election to fill the vacancy, provided the election is held in accordance with the requirements of your documents to hold elections. Now, what is the term of that replacement director or successor director? Well, unless otherwise provided by your bylaws, a board member appointed to fill a vacancy that occurred because of death or resignation or something like that, they serve the unexpired term of the seat being filled, again, unless your bylaws provide otherwise. More about the board and board meetings. Officers and directors have a fiduciary responsibility to the board. To the owners. Fiduciary, big fancy word meaning basically trust. They must act reasonably, but there is something known as the reasonable business judgment rule. Basically, what that means quickly is, as long as you're acting reasonably and in good faith, then really your decisions can't be challenged. Well, they can be challenged, but they won't be successfully challenged. Anyone can challenge anything, but so directors don't always have to be right, okay? And that's impossible. None of us are always right. But as long as they're acting reasonably and in good faith, then the reasonable business judgment rule protects directors in acting in that manner. Now, unless otherwise provided by your documents or in the law, the association's powers are exercised by the board. And generally speaking, almost all decisions, quite frankly, are flowed through the board. Very few things actually go to the members, contrary to membership belief sometimes. Obviously, certain things are elections, are owner decisions, amendments to documents are generally owner decisions, but it's a pretty short list of what the owners actually vote on. Usually the association, for the most part, is operated and run through the board. Unless delegated, no one board member should be making decisions for the board. So again, and I've seen this through the years where usually the president, but sometimes, one person pretty much is calling all the shots. And that's not the way it works. Okay. It is a board. You act collectively. You don't always have to agree, and that's perfectly fine. But you act through consensus and you act collectively. Directors may not vote by proxy or by secret ballot. We mentioned this before, except you can use secret ballots in the election of officers. That's the only time. Members of the board can use email to communicate with each other, but you cannot vote on the matter via email. Now, board meeting notices. We talked about membership meeting notices before. With respect to board meeting notices, they must include the date, time, and place of the meeting and must specifically identify all agenda items for the meeting. Now, if you're going to do an assessment levied at that meeting, whether it's a budget or a special assessment, okay, the notice of the meeting must include a statement that assessments will be considered and the nature of the assessment. Now, most meeting notices are a 48-hour notice. So unless the bylaws provide otherwise, notice of all board meetings must be conspicuously posted in the community at least 48 hours before a meeting, except in an emergency. And by the way, that's a bona fide emergency. Okay, that's not just some kind of made up, we're going to use the word emergency. It means a bona fide emergency under emergency condition. Now, there are certain board meetings where you need a 14-day notice. We spoke about one of them a few minutes ago when you're going to adopt electronic online voting. The board's going to adopt online voting. That's done pursuant to a board meeting with a 14-day notice. In addition, if you're going to adopt a special assessment or an amendment to a rule regarding the use of a lot, okay, that meeting must be pursuant to a 14-day notice, and that 14-day notice must be mailed, delivered, or electronically transmitted to all the owners, again, 14 days in advance, and conspicuously posted on the property in the community at least 14 days before the meeting. So those are your 14-day requirements. In addition to those notice requirements, you may, not required to, but in addition to what we just mentioned, you may adopt by rule a procedure for conspicuously posting the board meeting notice and agenda on your website or an app, okay, for at least the minimum period of time for which notice is also required to be physically posted. So you can do both. Any rule adopted must include a requirement that the association send electronic notice to the members whose email addresses are included in the association's official records in the same manner as is required for notice of members of the meeting or meeting of the members. And such notice must include a hyperlink to the website or app on which the meeting notice is posted. Also, a new law, okay, and we already mentioned this, we'll mention it again. By January 1 of this year, associations that have 100 or more parcels, so 100 plus, must have a website or app and must post notice of any board meeting, agenda, and any other document required for such a meeting no later than the date required for the notice on your app or website. Similar to membership meetings, owners also have a right to attend almost all board meetings, okay? The only ones that are closed to the membership or can be closed to the membership are meetings between the board and its attorney and the association's attorney with respect to proposed or pending litigation where the content of the discussion would otherwise be governed by the attorney-client privilege. That's number one. Number two is meetings held for the purpose of discussing personnel matters, and that can be hiring, firing, discipline, suspension, things like that. So personnel matters, as well as attorney-client litigation matters. Now, members have a right, other than what I just mentioned, members have a right to attend all board meetings and the right to speak at any board meeting with reference to all designated items, in other words, anything on the agenda. The association may adopt reasonable written rules regarding the frequency, duration, and other manner of member statements, including, for example, requiring people to sign up to speak at the meeting. Unlike a member's right to speak at members' meeting, there is no statutory prescribed time limit. We had a 3-minute time limit for members' meetings. There is no statutory time limit to speak, although a minimum of 3 minutes to me is still a good idea. I think that's reasonable. And if you're going to adopt rules regarding participating in meetings, I suggest then you include that 3-minute time period in your rules. Now, recording and handicap access, and we mentioned this before, similar to members' meetings, an owner may audio or video record or videotape board meetings. And you can adopt reasonable rules regarding the recording or taping of the meetings. And similarly with handicap access, board meetings must also be held at a location accessible to physically handicapped persons if requested by a physically handicapped person who has a right to attend the meeting. How about getting paid? You guys want to get paid? Well, unlikely, but not impossible. A director, officer, or committee member may not directly receive any salary or compensation from the association for the performance of duties as a director, officer, or committee member, and may not in any other way benefit financially from service except for the following: participation buys that person in a financial benefit accruing to all or significant number of members as a result of actions lawfully taken, reimbursement for out-of-pocket expenses incurred on behalf of the association, subject to applicable approval procedures, and you should have internal controls regarding that reimbursement, by the way. Recovery of insurance proceeds derived from a policy of insurance maintained by the association for the benefit of its members. Any fee or compensation which might be authorized by the governing documents or by a vote of a majority of the voting interests, voting in person or by proxy at a meeting of the members. There was also an exception for a developer or its representative serving as a director, officer, or committee member of the association. No kickbacks. And this should be obvious, and that you can't take kickbacks, but we'll go over it quickly. A director, officer, or manager cannot solicit, offer to accept, or accept a kickback. What is a kickback? It's anything or service of value for which consideration has not been provided for an officer's, director, or a manager's benefit, or for the benefit of an immediate family member from any person providing or proposing to provide goods or services to the association. So it doesn't have to be necessarily just a bag of cash, right? Given to you by some vendor. It could be that, the vendor is going to paint all the houses in the community, and as a kickback, he's going to paint the inside of your house, for nothing in order to give him the job. So basically, you can't get anything of value for which you haven't, paid your own consideration. An officer or director or manager who knowingly violates this prohibition against kickbacks commits a third-degree felony and is subject to monetary damages. Also, any officer or director who has violated that provision or that prohibition must also be immediately removed from office by the board, and that creates a vacancy to be filled until the end of the term of office. However, there are a couple minor exceptions. You can, take or accept food to be consumed at a business meeting with a value of less than $25 per individual, or service or a good received in connection with trade fairs or education programs. So, we do a lot of these trade shows and trade fairs, and everyone's got their little tchotchkes and things on their tables that they give away. So getting a pen or a squeezy ball at a trade fair is not a kickback. Now, there's also grounds for immediate removal from the board, okay? And these are similar to some things we already mentioned, but okay, you're immediately off the board if you're charged, okay? This is not necessarily, again, not convicted, but even just charged or indicted for forgery of a ballot envelope or voting certificate used in an election, as provided in section 831.01, theft or embezzlement involving the association's funds or property as provided in that statute. Again, not convicted, but just you've been arrested, charged, indicted. Tampering with physical evidence, destruction of or the refusal to timely allow inspection or copying of an official record in furtherance of any crime, obstruction of justice, and any criminal violation under the HOA Act. All of these things are grounds for immediate removal from the board. In that event, the board must fill the vacancy until the end of the period of the suspension or the end of the director's term of office, whichever occurs first. If the charges are resolved without a finding of guilt or without acceptance of a plea of guilty or nolo contendere or no contest, the director or officer must be reinstated for any remainder of his term of office. Again, these are not permanent removals, okay? But as long as those charges are pending, you're off the board, but they need to be dismissed, or dropped, in order to be reinstated. If the criminal charge is pending, the person may not be appointed or elected to a position as an officer director of any association, not just this one, any association, and may not have access to the official records of any association except pursuant to a court order. Now, another way to be kicked off the board, for lack of a better phrase, is a director who becomes more than 90 days delinquent in the payment of any fee, fine, or other monetary obligation to the association is deemed to have abandoned his or her seat on the board, creating a vacancy on the board to be filled according to law. So unlike the other ones where you're suspended until the matter has been dropped or dismissed, if you're off the board because you're more than 90 days delinquent, you are off the board. When you become current, you're not reinstated. That's a permanent abandonment. Permanent in the sense of if you become current and then you can run for the board the next election cycle, but you're not reappointed, just because you ended your delinquency. Conflict of interests. And there's a certain way, I generally tell my clients to try to avoid these kind of contracts, but if for whatever reason the association wants to do them, this is the manner to enter into a contract or a transaction in which a director has a conflict. Okay. Directors and officers must disclose to the association any activity that may be reasonably construed to be a conflict of interest at least 14 days before voting on any issue or entering into a contract that is a subject of that conflict. There's a rebuttable presumption of a conflict if any of the following acts occur without prior disclosure to the association. A director or officer or a relative of director or officer enters into a contract for goods or services with the association. A director or officer or relative of director or officer holds an interest in a corporation, LLC, partnership, LLP, or other business entity that conducts business with the association or proposes to enter into a contract or other transaction with the association. So again, this applies to directors entering into these contracts or the relatives of a director entering into contracts with the association. If you enter into a contract or other transaction with a director or a corporation or other entity in which the director has a financial interest, then the board must comply with the following requirements, okay? The proposed contract must be fully disclosed to the board, and the disclosure entered into the minutes of the board meeting at which the proposed contract will be considered and voted upon, and it must be approved by 2/3 of the directors present. The contract must be reasonable and fair to the association. At the next regular or special meeting of the members, not board, of the members, the existence of the contract or transaction with the director must be disclosed to the membership. At that meeting, upon a member's motion, the contract may be canceled by a majority vote of the members present at the meeting. If they do cancel the contract in that manner, the association is only liable for the reasonable value of goods and services provided up to the time of cancellation and is not liable for any termination fee, liquidated damage fee, or other kind of penalties. Now we're going to discuss official records. And this is important because this comes up all the time. What are the official records of an association? Well, there's a list, and here's the list. Any plans, specifications, permits, and warranties related to the improvements on the common area or other property that the association is obligated to maintain. A copy of your governing documents. That's a declaration, articles, bylaws, and rules, and all the amendments to those documents. The association must maintain an adequate number of copies of these documents, recorded documents, to ensure their availability to members and prospective members. The minutes of all meetings of the board and of the membership. A current roster of all your owners and their designated mailing addresses and lot identifications, and the email address and fax numbers for those members who have consented, again, in writing, to receive notices by electronic transmission, and they haven't revoked that consent. Your insurance policies or the association's insurance policies. A copy of all contracts that the association is a party to, and all bids received by the association for work. Financial and accounting records must be kept according to good accounting practices, and those are part of your records, specifically accurate, itemized, and detailed records of all receipts and expenditures, a current account, and a periodic statement of the account for each member, which must designate the name and current address of each member who is obligated to pay assessments, the due date and amount of each assessment or other charge against the member, the date and amount of each payment on the account, and the balance due. All tax returns. Good. So that second bullet point, or excuse me, third bullet point, again, for every owner, you have to have basically a statement of account for that owner covering all those matters. All tax returns, financial statements, and financial reports. A copy of the disclosure summary, which is described in 72401. Ballots, sign-in sheets, voting proxies, and any other papers and electronic records relating to voting by owners. And all those voting records must be kept for at least 1 year after the date of the election or the vote. All affirmative acknowledgments made pursuant to 723.085, blah, 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 Florida statutes. The affirmative acknowledgement, that's an acknowledgement for how an owner is to receive their invoices from the association. And in the bottom, which is a catch-all, all other written records of the association that are not specifically identified above, which are related to the operation of the association. So the records are pretty broad as to what is included as an official record of the association. Now you have to maintain the official records for at least 7 years, unless your governing documents require a longer period of time to maintain them. Bids received for any work must be kept for at least 1 year. Effective last year, the association must adopt written rules governing the method or policy by which the official records are to be retained, and the time period such records must be retained. That information must be made available to the owners through your website or app. Now, there are certain records, after we talked about all that, that are not accessible to other owners, okay, or not accessible to the owners. What are those? Okay, records protected by attorney-client or the work product privilege. Attorney-client basically is anything that the attorney sends to you or that you send to the attorney. That's protected by attorney-client. The work product privilege is any record which is made pursuant to the instruction, direction of the attorney, usually related to litigation or threatened litigation, pending litigation. That's the work product. The attorney-client is the direct communication. All right. Information obtained by the association in connection with the approval of a lease, sale, or other transfer of parcel. So the application of lease or application of sale, the background information, any other information that the owner or the tenant has been required to submit. Although that stuff gets reviewed by the board, it is privileged in the sense that no other owners are allowed to have access to the information that's in that file. Information obtained in a gated community in connection with guests, visits to owners or residents. That's privileged. You can't see who's coming to visit me. Social security numbers, driver license numbers, credit card numbers, email addresses, telephone numbers, fax numbers, emergency contact information, and any address other than as provided for association notice requirements, and any other personal identifying information, not including the person's name, lot number, mailing address, and property address. So all the information you notice in there includes phone numbers and email addresses. All that is privileged and not accessible, okay? Again, not including the email and fax numbers that owners provide for notice purposes that they've agreed to in writing that the association uses for notice purposes. Now, the association is not liable for the disclosure of protected information if the information is included in an official record and is voluntarily provided by an owner and has not been requested by the association. Other things that are not accessible: personnel records of association or management employees. medical records of owners or other residents. Stop here for a second. Medical records, remember, and we're not sure we're going to talk about it that much in this presentation, but as a board member, you're probably going to be asked from time to time to evaluate whether someone is entitled to an accommodation for, let's say, an emotional support animal. And generally speaking, in those instances, they will be required to submit some sort of documentation from their medical professional. That letter, that documentation, that's a medical record. It's not accessible to other owners. Okay. Any electronic security measure that is used by the association to safeguard data, including passwords. The association's software and operating system, which allows the manipulation of data, even if the owner owns a copy of the same software used by the association. That's not accessible either. And again, all the affirmative acknowledgements made pursuant to 723.085. So that's all the privilege stuff. We talked about attorney-client privilege a little bit, talk about a little more here. Okay, so what's not accessible? Any record protected by the lawyer-client privilege, as set forth in section 90.502 of Florida statutes, and any record protected by work product privilege. That includes any record prepared by an association attorney or prepared at the attorney's express direction, which reflects a mental impression, conclusion, litigation strategy, or legal theory of the attorney or the association, and was prepared exclusively for civil or criminal litigation or for adversarial administrative proceedings, which was prepared in anticipation of that type of proceeding until the conclusion of the litigation or the proceeding. And then importantly, that second bullet point, correspondence from the association's attorney remains privileged unless the board waives the privilege. So the association's counsel cannot waive the privilege. So when we write the association a letter, and someone else asks for it, no. If the association voluntarily distributes that letter, they've waived the privilege. The attorney cannot waive the privilege. Membership directories. You can print and distribute to the owners a directory containing the name, address, and telephone numbers of each owner. However, an owner can exclude his or her telephone numbers. Remember, telephone numbers are not accessible normally from the directory by so requesting and writing to the association. If you're going to do a directory, give owners a reasonable opportunity and ability to opt out of having their phone number in and make sure it's clear. You don't want to inadvertently put phone numbers in there that you weren't supposed to. An owner can also provide written consent to disclosure of other contact information, which is otherwise not accessible. So we mentioned before that email addresses are not accessible unless the owner has agreed that that's their notice address for notice from the association. However, an owner can otherwise agree to let other owners see it. Okay, so an owner can consent to that. Providing rules and covenants. Okay, and this was new as of last year. Before October 1st of last year, an association was required, and obviously still required, to provide a physical or digital copy of the association's rules and covenants declaration to every member. You must provide a physical copy of the rules and covenants to every new member. If the rules or covenants are amended, you must provide every member with an updated copy of the amended rules or covenants. An association may adopt rules establishing standards for the manner of distribution and time frame for providing copies of the updated rules or covenants. The association can comply with this requirement by posting a complete copy of the rules and covenants or a direct link on the homepage of its website, provided the website is accessible to the members of the association, and you send notice to each member of his intent to utilize the website for this purpose by emailing to any member who has consented to receive notice by email, and provide an email address to the association for that purpose, and mail to all the other members at the address that identified the member's mailing address in the association's official record. So you can send out that notice to owners by email who've consented to get notice that way. Otherwise, you have to mail that notice to everybody. Access. So we talked about what are the records. We talked about certain records that owners don't have access to. How about actually providing access? And here we're going to talk about that. Unless otherwise provided by law or your documents, the official records must be made available for inspection within 45 miles of the community or within the county within 10 business days after receipt of an owner's written request. You may have a copy of the records available for inspection in the community. You may make them available electronically via the internet, and you may allow the records to be viewed in electronic format on a screen and printed upon request. So it's 3 different ways to make the records available. If a request is submitted by certified mail, return receipt requested, and access to the records is not timely provided, there is a rebuttable presumption that the association willfully failed to comply. So what happens if you fail to comply with the right of an owner to have access to the records? A member who's denied access is entitled to actual damages, if there are any, or at least minimum damages for your willful failure to comply. The minimum damages are $50 a day. Again, that's calendar day, up to 10 days, so $500. And that calculation begins on the 11th business days after receipt of the written request for the records or access to the records. If you receive a subpoena, again, this is also new as of last year, for records from a law enforcement agency, then you must provide a copy of such records or otherwise make the records available for inspection and copying to the law enforcement agency within 5 business days after receipt of the subpoena, unless otherwise specified by the law enforcement agency or subpoena. And you must assist a law enforcement agency in its investigation to the extent permissible by law. Official records, there's some crimes related to monkeying around with official records, and these are the things that go to that level of criminal activity. Any director or manager who knowingly, willfully, and repeatedly, which means 2 or more times in a 12-month period, fails to provide access to the official records with the intent of causing harm to the association or one or more of its members, and that's a commission of a second-degree misdemeanor. Any person who knowingly and intentionally defaces or destroys accounting records during the period which such records are required to be maintained, or who knowingly and intentionally fails to create or maintain accounting records, again, that are required to be created or maintained, with the intent of causing harm to the associate or one or more of its members, that's a first-degree misdemeanor. And any person who willfully and knowingly refuses to release or otherwise produce association records, again, with the intent to avoid or escape detection, arrest, trial, or punishment for the commission of a crime, or to assist another person with such evidence or escape, commits a 3rd-degree felony. Again, I'm sure no one in this webinar is going to be committing any of this stuff. Now, you can adopt, and it's probably a good idea to, obviously, not obviously, but in our opinion, my opinion, an association may adopt reasonable written rules governing the frequency, time, location, notice, records to be inspected, and manner of inspection. However, you cannot, and this is important, you cannot require an owner to show any proper purpose for the inspection, require an owner to state any reason for the inspection, limit an owner's right to inspect records to less than 1 8-hour business day per month. Now, I've been doing this a long time, and so many times I hear from my clients, we're not going to give the records to so-and-so. So-and-so just wants them to harass us. Or, so-and-so is such a pain in the whatever, And I'm telling you, that is just, I don't care if that person is your worst enemy, is the worst enemy in the community, whatever. You cannot hold records. I'm going to use the word hostage, okay? You cannot deny records. You cannot ask why they want those records. It's irrelevant, okay? You can enforce your reasonable rules and regulations regarding the records, frequency, time, location, notice, manner, all right? But their motivation for getting the records, their purpose for having the records, even if in your heart you think it's some evil thing, trust me, give access to the records. Record inspection or record access is strictly enforced. You have to be transparent. That's an overused word, but in this instance, it does apply. So I'm not going to harp on this anymore, but just be aware. Now, under the law, a member or their representative is allowed to use a portable device like a smartphone, a tablet, a portable scanner, or any other technology capable of scanning or photographing to make an electronic copy of the records. You can't charge an owner for doing that. So if an owner wants to use their tablet, their smartphone, portable scanner to make their own copies or pictures, they're allowed to do so. If you have a photocopy machine where the records are maintained, the association must provide owner, and again, and they're not using their own, copy equipment or whatever, scanner, tablet. It must provide owners with copies on request during the inspection if the entire request is not more than 25 pages. You can charge up to 25 cents per page for copies made on the association's equipment. If the association does not have a photocopier, or if the records requested exceed 25 pages, then you can have them made by an outside duplicating service and may charge the actual cost of copying as supported by the vendor invoice. So if they've asked for more than 25 pages, you don't have a copier there, again, or they're more than 25 pages, even if you have a copier, but you want to send them out, and you're going to send them out to Office Depot or something, you can do that, but you can only charge them the actual invoice that you receive. What about personnel costs, to use your people? The association may charge, or your employees, the association may charge for the costs required for personnel to retrieve and copy the records if the time spent retrieving and copying exceeds half an hour and the personal costs do not exceed $20 per hour. You cannot charge personnel costs for record requests that result in copying of 25 or less or fewer pages. Website. And we mentioned this already a little bit. I'm going to repeat ourselves. Again, by January of this year, if you have 100 or more lots, you had to have a website or a downloadable app for posting the association documents. The association website or app must be accessible to the internet and must contain a subpage, web portal, or other protected electronic location that is inaccessible to the general public and only accessible to the owners, employees of the association. Upon written request of an owner, the association must provide the owner with a username and password and access to the protected sections of the website or app, which contains the association's documents. A copy of the following here must be put on the website or posted on the website. Your declaration, articles, bylaws, and all the amendments. Your current rules. A list of all current executory contracts or documents to which the association is a party, or under which the association or the owners have an obligation or responsibility. And after bidding for materials, equipment, or services has closed, a list of bids received by the association within the past year. The annual budget and any proposed budget to be considered at the annual meeting. The financial report and any monthly income or expense statement to be considered at a meeting. Your current insurance policies for the association, and the certification of each director, i.e. what you're going to get today. All contracts or transactions between the association and any director, officer, corporation, firm, or association that is not an affiliated homeowner association or any other entity in which the association director is also a director or officer and financially interested. Any contract or document regarding a conflict of interest or possible conflict of interest. Notice of any board meeting and the agenda and any other document required for the meeting, which must be posted no later than the date required for the notice to be posted. Notice of any membership meeting and the agenda for the meeting, that has to be up there or posted at least 14 days before the meeting, posted in plain view on the home page or on a separate subpage labeled notices, which is conspicuously visible and linked from the home page. The association must also post any document, we mentioned this before, to be considered and voted on by the membership during the meeting, or any document listed or identified on the meeting agenda at least 7 days before the meeting at which the document or information within the document will be considered at that meeting. Now you have to ensure that the information and records which are not allowed to be accessible to owners are not posted on the website. We just talked about certain records which are inaccessible to owners. And I'm not going to go through that again, but those things you have to make sure are not posted on your website or in the app. If protected information or information restricted from being accessible to owners is included, that are required to be posted on the website, then you must ensure they're redacted. So if you have a document which otherwise must be posted, but it has, privileged or inaccessible information on there, you got to redact that out before you post it. However, the association or its authorized agent is not liable for disclosing protected or restricted information unless such disclosure was made with a knowing or intentional disregard of the protected or restricted name. So there's no liability if it's an oops, okay, or an inadvertent error. But there is, that doesn't apply to a knowing or intentional disregard of the protected nature of it. How about amending your documents? What vote is needed to amend your documents? And in most documents, articles, declaration, bylaws have an amendment provision which specifies what approval vote is needed. However, unless otherwise provided, if it's silent, you have to get the vote of the amendment is a 2/3 vote of the voting interest. Again, but typically each document does have an amendment section, and that could be anything from 2/3, 75%, majority. It's all over the place. There's no set rule. Amendments to the articles and bylaws which affect or impose a quorum or voting requirement greater than a general quorum or amendment voting requirement are not required to be approved by that greater quorum or voting requirement in effect if you're trying to lower the threshold. So if you're trying to lower the threshold, to amend, let's say from, or from 2/3 or something else, you don't need the 2/3 to amend the 2/3. Format. Proposed amendments must be formatted to show new text and underline and deleted text and strikeout. Let me go back because I think I said something that might have been misleading. Okay. Follow the vote required to amend the document. Okay. Follow the vote required to amend the document. If you have some specific provisions that might have higher quorum or higher voting requirement, you can still use the regular voting requirement to lower those. All right. Proposed amendments must be formatted to show new text and underline and deleted text and strikeout. So basically, you have to show the section being amended with new language underlined and language being deleted shown as stricken through. However, if the proposed change is so extensive that that kind of formatting will make it confusing or hinder the understanding of the amendment, then you can have the following notation immediately before the proposed amendment: substantial rewording, see governing document for concurrent text. So if the amendment is so extensive that to strike out and underline makes it hard to read or hard to understand, then you can just put in clear text without the strikeouts, but you have to say, basically, this is a substantial rewording of this section. Please see, the current document for the current text so you can compare. What about lender consent? To amendments, and some documents call for that. Okay, under the HOA Act, that sets forth the process of amending the government documents when mortgagee consent to an amendment is required. And what that says basically, if after 60 days of sending the amendment to the mortgagee, there's no response, that mortgagee or the lender has deemed to consent to the amendment. What's the effective date? An amendment is effective upon when recorded in the public records of the county in which the community is located. Within 30 days after recording an amendment to the governing documents, you must provide copies of the amendment to the members. However, if a copy of a proposed amendment is provided to the members prior to the membership meeting vote to approve the amendment, and usually they are, and the proposed amendment was unchanged before the vote, then the association can provide notice to the members that the proposed amendment was adopted and that a copy of the amendment is available upon written request at no charge to the member. This notice must also provide the official record, book, and page number or instrument number of the recorded amendment. However, the failure to timely provide notice of the recording of the amendment does not affect the validity or the enforceability of the amendment. But remember, you still have to provide all the owners with all your covenants and all your amendments to your covenants. So now here's just some practical things to know, in operating the association, and some things that are statutory as well. Okay, you have two governmental filings, at least two of them you have to do every year. One is to the Division of Corporations. To maintain an active corporate status, you must file your annual report with the Division of Corporations between January 1st and May 1st of each year and pay a filing fee. And that report generally indicates your mailing address, your registered office, or excuse me, your registered agent, and his or her address or its address, and who are the officers and directors. So that annual report has to be filed every year. You're not tax exempt, people, okay? And you have to file an annual income tax statement. Contrary to popular belief, not-for-profits are not tax exempt. You're not a church, or you're not a school. And while assessments are not taxable, other revenue will be taxable. So, I'm not a tax guy. I'm not an accountant, I'm not a tax advisor. So, regarding your tax situation, speak to your CPA or your other tax advisor regarding, the filing of your annual tax return. Meeting minutes. All meetings must have minutes. Meeting minutes do not have to be verbatim, and please do not make them verbatim. There is no reason to include every cough, burp, or other noise in your meeting minutes, or every verbatim statement made by anybody, quite frankly. And in my experience, those verbatim minutes just are more hindrance than help. Okay. Minutes are supposed to be minutes. In other words, what is a motion? That needs to be put verbatim. Okay. Who seconded the motion? Okay. What is the vote on that motion? Now, here it's important that you have to include a vote or abstention on each matter voted upon. And you can't just say it passed 4-3 or it failed 4-3. You have to indicate how every director voted, either yes, no, or abstention. Okay. And the minutes must be maintained in a written form or another form that can be converted to a written form within a reasonable time. Material alterations. This is usually more of a condominium issue, but it does apply to HOAs too, but not in the same way. There's a condominium case called Sterling Villages versus Breitenbach that basically has defined for both, well, for condos especially, but we think it applies to HOAs too. What is a material alteration or addition with respect, let's say, to your common area? And that means to palpably or perceptibly vary or change the form, shape, elements, or specifications of a building from its original design or plan or existing condition in such a manner as to appreciably affect or influence its function, use, or appearance. So basically, anything that affects use, appearance, or function in any kind of palpable way is likely going to be a material alteration. So what's the approval? Well, for HOAs, the statute's silent. Okay, so Chapter 720 does not address this issue. Chapter 718 for condominiums, it does very specifically, but HOAs, it doesn't. So for an HOA, you really got to look to your documents. Okay, what do your documents say about the approval of improvements, alterations to the common area? Oftentimes it's board, sometimes it's owner, sometimes it's board and owner. If confused, consult with your attorney. I'm not trying to shill for attorneys here, but this is something that's in HOAs entirely document driven and not governed by statute. The rules and regs. Okay, as I mentioned before, rules and regs, although not governing documents in the sense of being recorded, okay, they are still very important documents. And who's authorized to adopt those? Well, it depends upon your documents. Some people automatically think, oh, the board is. I've seen many documents that require owner approval for rules as well. So you got to look through your declaration, articles, and bylaws to really figure out who has the right to adopt rules and over what. Because I've seen some documents that only give the authority to pass rules regarding common area and not with respect to the use of the lots. So again, this is something as also it's driven by your documents, not by statute, as far as the authority to adopt and what those rules can cover. So again, typically by the board, not always. If you do have the authority to pass rules regarding the use of a parcel or a lot, okay, then as I mentioned, a bit ago, that's a type of board meeting which is a special kind of notice. It's not a 48-hour notice. If you're going to adopt rules or amend rules regarding the use of a lot or the use of a parcel, that's a 14-day meeting notice sent to all the owners and posted 14 days in advance. Okay. If you're going to make rules, let's say about though other things like record inspection or rules regarding speaking and participating at meetings, those are board rules, and those are board rules done at 48-hour meeting notices. If you're going to adopt rules regarding use of the common area, that's another rule with a 48-hour notice unless your documents provide for, a different notice requirement. The Marketable Record Title Act, or what we call MARTA, MRTA. This deals with preserving your documents. So if you're in a community that's getting a little older, just please be advised that a declaration of covenants, and this doesn't apply to condos, this only applies to HOAs. Condos are not under this. And I won't go into why, but they're not. But a declaration of covenants will expire on a lot by lot basis 30 years after the declaration was recorded, unless they're preserved. Okay, it's very important to make sure that they're preserved. There's 3 different ways to preserve them. Written notice under section 71206, summary notice under 72303(2), or up to October 1st, 2018, an amendment. If they're not preserved, okay, if they're not preserved, then the association must undergo the revitalization process, which requires members, actually, it's as of October 1st, 2018, apologize. If they're not preserved and they expire, then you have to revitalize them. Whereas the preservation is a board vote and a board action, the revitalization is a pretty complicated process and it's a membership vote. So if at all possible, make sure your documents are preserved before that 30-year anniversary. Emergency powers, okay? This became a super hot topic in HOAs and condos, a little more in condos because of the nature of the way they're, constructed and they're the way they are. But back in the lovely COVID time in 2020, emergency powers were everywhere because of that emergency and things being shut down and what can the association shut down, what can't the association shut down. So actually the law was changed post the pandemic. But I'll go into what it says now. So this is 72316, which is emergency powers. So unless specifically prohibited by your documents, recorded documents, you can exercise emergency powers in response to damage or injury caused by or anticipating in connection with an emergency for which a state of emergency is declared in the area encompassed by the association. So for us down here, usually that's when the governor declares a state of emergency for, let's say, a hurricane. Okay, so if where your HOA is, and the governor declares a state of emergency for that area, then you can exercise these powers. These powers are only available to the board for a period of time that is reasonably necessary to protect the health, safety, and welfare of the association and the owners and their family members, tenants, guests, agents, or invitees, and to mitigate, or in other words, lessen, mitigate further damage, injury, or contagion. They threw in contagion after COVID, and make emergency repairs. These emergency powers include, so what are these powers? You can conduct meetings in whole or part by telephone, real-time, video conferencing, or other real-time electronic or video communication after providing notice as practical manner as possible. And that can be publication, radio, mail, internet, email, whatever. Notice of decisions may also be communicated in that manner. There's other powers. Cancel and reschedule meetings. Designate assistant officers who are not directors to step into the shoes of an officer in the event the officer is incapacitated or unavailable. Relocate or designate an alternate principal office. Enter into agreements with counties and municipalities to assist counties and municipalities with debris removal. Implement a disaster or emergency plan before, during, or following the event for which the emergency was declared. Stuff like shutting off elevators, electricity, water, sewer, security, AC units. Determine whether any portion of the common area to be unavailable for entry or occupancy by owners or their family members, tenants, guests, whatever, based on the advice of emergency management officials, public health officials, or licensed professionals retained or otherwise available to the board. If you want to shut down the clubhouse or something like that.
All right, I fell asleep at the wheel there for a second because I was chuckling at a message in the chat. Folks, if you need to take a bio break, uh, go ahead, do your
Yep.
thing. Come on back. Just leave it running. Leave the webinar on. Come on back, and you don't have to let us know. Back to you, Peter. Oh, let me change the screen there.
Whoops. Okay. More emergency powers. Determine whether the common areas can be safely inhabited, accessed, or occupied. Again, based on the advice of emergency management officials, public health officials, or licensed professionals, retained or available to the board. You can mitigate damage, injury, contagion by removing debris, wet drywall insulation, carpet, cabinetry, or other fixtures within the common areas. Again, we're talking about clubhouses, things like that. You can levy a special assessment without a vote of the owners, notwithstanding that your documents may otherwise provide, and regardless of whether that authority explicitly appears in the governing documents. Again, for emergency purposes, though, without owner's approval, borrow money and pledge association assets as a collateral to fund the repairs, emergency repairs, and carry out the duties of the association if operating funds are insufficient. Now, that authority is in addition to the other authority you may have to borrow money, subject to any restrictions that are in the governing document. So all these things are in the event, there is a declared emergency. Now, what can't you do even under those powers? You cannot prohibit owners, tenants, guests, agents, or invitees from accessing the common area and facilities for purpose of ingress and egress from the parcel when necessary in connection with the sale, lease, or other transfer of parcel. We had a lot of this come up during the pandemic about, are real estate agents allowed in? Are they not allowed in? So this addresses that. Or the habitability of the parcel, or for the health and safety of such person, unless a governmental order or determination or a public health directive from the Centers for Disease Control and Prevention has been issued prohibiting access to the parcel. Any such access is subject to reasonable restrictions adopted by the association. We're gonna talk a little bit about debit cards, because this is, for some people, this is new and not known yet. An association and its officers, directors, and employees and agents cannot, that's a cannot, use a debit card issued in the name of the association or billed directly to the association for the payment of any association expense. But don't be using debit cards. A person who uses a debit card issued in the name of the association or billed directly to the association for any expense that is not a lawful obligation of the association commits theft. So what's a lawful obligation? The term lawful obligation of the association means an obligation that has been properly pre-approved by the board and is reflected in the meeting minutes or the budget, the written budget. What about suing, bringing lawsuits, or bringing legal action? Well, the association may, in other words, is entitled to institute, maintain, settle, or appeal actions or hearings in its name on behalf of all members concerning matters of common interest to the members, including but not limited to the common areas, roof, or structural components of a building or other improvements for which the association is responsible, mechanical, electrical, or plumbing of elements serving an improvement or building for which the association is responsible. So you can bring an action based on those common things. With respect to representations of the developer pertaining to an existing or proposed commonly used facility, protesting ad valorem taxes on commonly used facilities, property taxes, and defending an eminent domain lawsuit and bringing an inverse condemnation claim. Interestingly, the last bullet point, before commencing litigation against any party in the name association involving matters in controversy in excess of $100,000, the association must obtain the affirmative approval of a majority of the voting interests at a meeting of the membership at which a quorum has been obtained. And I've had to do that. I had an association that was suing an insurance company for more than 100,000. Had to get the approval from the owners first because the matter controversy was more than 100,000. Architectural control. And this is something that you guys are going to be active in for those of you who are new, or through your ACC committees. Effective last year, an association must reasonably and equitably apply and enforce on all owners the architectural and construction improvement standards or other published guidelines, standards authorized by the declaration. If the association denies an owner's request or application for the construction of a structure or other improvement on a parcel or on a lot, the association must provide written notice to the owner stating with specificity the rule or covenant on which the association relied when denying their request or application and the specific aspect or part of the proposed improvement that does not conform to such rule or covenant. So in doing this, number one, I would say if you haven't, adopt specific architectural standards, not just some general, no, everything has to be in harmony. That's not specific enough. So you should have specific architectural control standards, whether that's colors, styles, what's allowed, what's not allowed, materials, things like that. Because when you deny something, you have to specifically say why it was denied and why it didn't comply with those standards or those requirements. Now, you cannot, enforce or adopt a covenant or rule or guideline that limits or places requirements on the interior of a structure that is not visible from the lot's frontage or an adjacent parcel, an adjacent common area, or community golf course. So if you can't see it, it's not within your architectural control, basically. Requires the review and approval of plans and specifications for a central AC, refrigeration, heating, or ventilating system by the association if, again, those systems are not visible from the lot's frontage, an adjacent lot, an adjacent common area, or a community golf course, and is substantially similar to a system that is approved or recommended by the association. This next one's kind of interesting too. Stuff that people put on their parcels, and what can you do about that? Regardless of any covenant, restriction, bylaws, rules, or requirements of the association, and unless prohibited by general law or a local ordinance, an association may not restrict owners or their tenants from installing, displaying, or storing any items on a lot which are not visible from the parcel's frontage or an adjacent parcel, an adjacent common area, or a community golf course, including but not limited to artificial turf, boats, flags, vegetable gardens, clotheslines, and recreation vehicles. Hurricane protection. This is important because this is also new. The association must adopt hurricane protection specifications for each structure or other improvement on a parcel governed by the association. What is hurricane protection? Well, it includes, without limit, roof systems, permanent fixed storm shutters, roll-down track storm shutters, impact-resistant windows and doors, polycarbonate panels, reinforced garage doors, erosion controls, exterior fixed generators, fuel storage tanks, and other hurricane protection products used to preserve and protect structures or improvements on a parcel. So it's a whole laundry list of stuff there that's included with what's hurricane protection. These specifications that you adopt must comply with applicable building code and may include the color and style of hurricane protection products and any other factor deemed relevant by the board, again, provided they comply with your specs, comply with code. The association cannot deny an application for the installation, enhancement, or replacement of hurricane protection by an owner which conforms to the specifications which are adopted by the association. However, you may require an owner to adhere to an existing unified building scheme regarding the external appearance of the structure or other improvement on the parcel. So for example, and again, this is my opinion, this law is new, so there's not any case law on it yet that I'm aware of. But let's say, you have all barrel tile roofs through your whole community. That's how it was built. That's how it's been maintained. That's how it's been kept. Everyone has barrel tile. Someone wants to put in a flat metal roof, right? Because they think that's better for hurricane protection. And they argue, well, it's hurricane protection. You have to let me do it. I think in that sense, and now in that context, you can insist on the barrel tile style roof. Okay, and there are metal barrel tiles, so that may be okay as far as appearance. because you are allowed to still adhere to an existing unified building scheme. And to me, that would be a unified building scheme. Vehicle, and there was a lot of brouhaha about this. I'll spend a moment talking about this. Okay. This other new law, also effective last year. An owner, tenant, guest, or invitee cannot, or the association cannot prohibit an owner, guest, tenant, or invitee from parking his or her personal vehicle, which includes a pickup truck, in the owner's driveway or in any other area at which the owner, tenant, guest, or invitee has a right to park, as governed by state, county, and municipal regs. You can also not prohibit the parking of someone's work vehicle, regardless of any official insignia or visible designation, which is not a commercial motor vehicle as defined by section 320.0125 in the owner's driveway, or operating a vehicle that is not a commercial vehicle, as defined by 320.0125 in conformance with the state laws. Now, this caused a whole bunch of brouhaha and controversy when this law was adopted, because so many associations, and I'm not going to get into, this is personal taste, each association regarding, let's say, trucks, especially pickup trucks. But remember about, 18 hours ago, we were talking about Kaufman language and what laws can apply retroactively or not. Well, in my humble opinion, this law affects substantive rights. It's not procedural. It's not like a meeting notice requirement or a quorum requirement. So in our opinion, in our firm's opinion, and I think most practitioners who do what I do, this particular law would not override or impair an existing valid vehicle restriction, let's say, i.e. no trucks in the community, including the driveways, or no trucks on the driveways, as unless that community's documents had what we call Kaufman language, where it was subject to changes in the law. In other words, unless that declaration was subject to, let's say, Chapter 720 as amended from time to time. In the absence of that, I think an existing truck restriction, okay, that was in effect before this law was adopted would still be enforceable. Same thing with commercial vehicle, because a commercial vehicle under section 320.01, that's basically a dump truck. When you read that statute, I believe it's a truck that's 26,000 pounds or more. Okay. An average vehicle's, I think, 4,200 pounds. I think an average pickup truck's a little over 5,000 pounds. So 26,000 pounds is literally, a giant vehicle. But again, I think in the absence of Kaufman language, an existing commercial vehicle restriction will be enforceable. We'll see how this plays out in the courts. Pretty comfortable with that statement, though. Okay, contractor restrictions. An association's governing documents cannot prohibit an owner from inviting, hiring, or allowing entry to a contractor or worker on the owner's lot solely because the contractor or worker is not on a preferred vendor list of the association, which of course makes sense, right? But however, the association also cannot prohibit an owner from inviting, hiring, or allowing entry to a contractor or worker on his lot or on his home because the contractor or worker does not have a professional or occupational license. The association may not require a contractor or worker to present or prove possession of a professional or occupational license to be allowed entry onto the property owner's parcel. Budgets and reserves. Everybody out there is going to have to do your budget, or at least approve your budgets. You may have management companies preparing them for you, but you're going to have an annual budget. So what goes into that? You must prepare an annual budget that reflects the estimated revenues and expenses for the upcoming fiscal year and the estimated surplus or deficit as of the end of the current fiscal year. The budget must set out separately all fees or charges paid for the association for recreational amenities, whether owned by the association, the developer, or another person. Now, typically a budget will have two components: operating expenses and perhaps reserves. Okay. I'm going to stop here for 1 second. Reserves for HOAs and condos are completely completely different, vastly different. Okay, especially now in the aftermath of the collapse in down in Miami Beach. Okay. And all the reserve stuff that condos are now going through, not HOAs. So HOA and condo reserve, then I'll explain why in a second here. Moving on, when you're doing your budget, you do use last year's budget as a template for this year's budget. Okay. And obviously make adjustments as they're needed. Now, the operating expenses portion of the budget identifies the categories of income and expenses that relate to the day-to-day operation of the association, whether that's maintenance, repair, those kind of things. The operating expenses must be listed by account and classification and should project the total proposed annual expenditure in each classification. Here's examples: administrative and management fees, maintenance and repair, as I mentioned, for the common area, rent, perhaps for recreation, other use facilities, probably not applicable, it could be, taxes on association property, insurance, and professional fees like attorney's fees, accounting fees, things like that. In addition, you may include reserve accounts for capital expenditures and deferred maintenance. Okay, what's a capital expenditure? That means any expenditure of funds for the purchase or replacement of an asset whose useful life is greater than 1 year, or repair to an asset that will extend the useful life of an asset for a period of greater than 1 year. Deferred is any maintenance or repair that will be performed less frequently than yearly and will result in maintaining the useful life of an asset. So both types of things of reserve expenditures or reserve stuff is pavement resurfacing, repairs or improvements to common areas like, painting of the clubhouse, replacing the roof of the clubhouse, stuff like that, sidewalk improvements, those type of projects. Now, stop here for a minute. The first bullet point says reserves may be created upon the affirmative approval of a majority of the total voting interest of the association. That's how if you're going to have a statutory reserve subject to the statutory restrictions of Chapter 720, they must be voted in by owners. In condominium associations, by law, they must have reserve budgeted. Okay. Certain reserves in a condo can be waived or reduced. Certain reserves for condominiums cannot be, for those that have buildings 3 stories or more. I'm not here to talk about condos, but you're going to hear a lot of talk about this. But in an HOA context, generally speaking, the reserves are not what I would call statutory reserves, because for that to happen, they have to be approved by a majority of the total voting interest of your association. Quite frankly, I'm not aware of any of my clients that have statutory reserves. If they do, they haven't told me. If the ownership, the membership approves, creating and maintaining reserves, then the board must then include the required reserve accounts in the budget in the next fiscal year, following year in which the membership vote was taken, and each year thereafter. Once established by a membership vote, statutory reserve accounts must be funded, maintained, or waived in the manner provided by statute. Okay. i.e., for example, that is, statutory reserves may be waived or partially funded only upon a vote of a majority of the members present at a meeting at which a quorum is present. Reserves created any other way are not subject to the calculation restrictions on the use of funds set forth in the statute. So let's say, for example, as in my view, or in my experience, I should say, most HOAs that have reserves, they're created by board action, board vote. Those are not restricted in the sense of they must be used for those reserve purposes. They're not subject to all the restrictions that statutory reserves are, and they can be used any way that the board determines. Obviously, it must be for an association related expense. Okay. But they're not limited. They're not restricted. Like, and really in any manner, even, the board can decide that they're going to be used differently than as they were initially proposed. Okay. Next. The amount to be reserved, again, statutory reserves, is based upon the estimated remaining useful life and estimated replacement cost or deferred maintenance expense for each reserve item. The association may adjust reserve assessments annually to take into account any changes in estimates of cost or useful life of a reserve item. Funding formulas for statutory reserves must be based on a separate analysis of each of the required assets or pooled analysis. What'd you do to me, Jeff? Or a pool or a pooled analysis of two or more of the required assets as defined in the statute. Unless you maintain pooled account for statutory reserves, the reserve schedule should include each reserve account for capital expenditures and deferred maintenance or replacement as a separate line item with the following disclosures, minimum disclosures: total estimated useful life, estimated remaining useful life of the asset, estimated replacement cost or deferred maintenance expense of the asset, and the estimated fund balance as of the beginning of the period for which the budget will be in effect. But again, these are all really gleaned from the condominium stuff, but only applying to HOAs for statutory reserves, which are those voted in by the membership.
Sorry about that glitch there, folks. Back to you, Peter.
Okay, that's right. We're making sure people are awake. Throw water at them. Changing use and pooled reserves. Okay. Using reserve for other purposes. Reserve funds, any interest accrued thereon must remain in the reserve account and can only be used to authorize reserve expenditures unless they're used for other purposes approved in advance by a majority of vote of the members of the meeting. Which, again, I mean, I know I repeated myself 100 times here, for statutory reserves, not for board-made reserves. Pooling reserves. The association may also establish pooled reserve accounts instead of or in addition to individual reserve accounts if an association establishes a pooled reserve account for two or more reserve items. Funds may be drawn from this account only to pay for any of the items in the pooled account. Individual versus pooled accounts, pooled reserve accounts. The difference between an individual reserve account and a pooled account is that instead of each individual reserve account having its own fund balance that can only be used for that particular reserve item or purpose, the money in the pooled account is available for costs affiliated with all the items that are in that pool. By the way, even though it sounds like it, I'm really not saying you shouldn't have statutory reserves. I'm not saying that at all. I'm saying in my experience, as a practical matter, the vast majority of HOAs do not have what I would call statutory reserves and have non-statutory reserves because they're board approved. Now, you do have to review your documents though. If your documents mandate that you maintain reserves in a certain manner, then obviously you must follow that. So that could also play a role. Waiving, reducing, and terminating reserves. Okay. After one or more statutory reserve accounts have been established in accordance with the statute, the proposed budget must include the statutorily defined reserves, and an association must fund those reserves unless the majority of the voting interest at a meeting at which a quorum is attained votes to either waive the funding or to partially fund them. The vote to waive or partially fund only applies to the applicable budget year the vote was taken. So it's a once, you got to keep doing it every year if you want to keep waiving or partially funding. Whether to submit a vote to the membership or waive or partially fund is within the discretion of the board, and not, in other words, you don't have to have the owners vote on that every year. You can just maintain the reserves and not vote for any kind of waiver or reduction. Terminating on reserves. Statutory reserves accounts established pursuant to the statute may be terminated upon the vote of a majority of the total voting interests of the association. So waiving them or partially funding them is a majority of those at a meeting at which a quorum is obtained. To terminate them is a majority of the total voting interest, which is a different level or different type of vote. Upon such approval, the terminated reserve accounts must be removed from the budget, and they end up going into operating. Notice and adoption of the budget. This is much different than the condos too. The governing documents must be reviewed for any specific budget meeting notice and adoption requirements because the HOA Act does not contain specific notice or agenda requirements for budget meetings. Condominium Act does. Homeowners Association Act doesn't. Okay. If your documents are silent, in other words, they don't address the adoption of a budget or the notice requirements and meeting requirements for the adoption of budget, then you're only required to do a 48-hour posted notice, just like any other board meeting. Before the budget adoption, unless the governing documents require the board to provide a copy of the proposed budget to all the owners before the meeting, you're not required to do so. But I think it's probably as a practical matter and as a good business operation, you should provide it to the owners before the board budget meeting. If your documents required you to, obviously you have to. But since the act is silent, you're not required to, unless your documents do. After budget adoption, once the budget has been adopted, the association then must provide each member with a copy of the budget or a written notice that a copy is available upon request at no charge. If requested, a copy of the adopted budget must be provided to the owner or the member within the time frame set forth for the inspection of association records, and i.e. within 10 business days after receipt of the request. By January 1st of this year, if you have 100 or more parcels, you also have to post a copy of the budget on your website or your app. Okay. Assessments and foreclosures. Okay. Assessments being what? The lifeblood of the association in terms of income. As I mentioned, I think previously, written notice of any board meeting at which a special assessment will be considered, that meeting notice must be mailed, delivered, or electronically transmitted to the members and posted on the property at least 14 days before the meeting. As a refresher, remember, you can only electronically transmit meeting notices to those owners who have agreed in writing to receive their notice in that manner. The notice of the meeting must include a statement that a special assessment will be considered and the nature of the assessment, and should identify the estimated cost of the assessment. Once levied, the association should send a written notice to the owners of the special assessment and allow the owners a reasonable period of time, with that period of time may be set forth in your documents, by the way, within which to pay the assessment. A special assessment that has not been paid by an owner can be collected in the same manner as regular assessments. In other words, subject to the same lien of foreclosure, but you have to make sure that you adopted it properly. Because if you did not adopt the special assessment properly, you didn't give proper meeting notice, you didn't send it out 14 days in advance, you didn't post it 14 days in advance, that is defense to paying that special assessment. So for example, when we collect special assessments for clients, we require that they give us, copies of the meeting notices and the affidavits of mailings and things like that, so that we know that the special assessment was properly adopted. Requirement to provide an accounting, something else that's new. Okay. A lot owner may make a written request to the board for a detailed accounting of any amounts that he or she owes to the association related to the parcel, a lot, and the board must provide such information within 15 business days after receipt of the written request. After the lot owner makes such written request to the board, he or she may not request another detailed accounting for at least 90 days. Okay. Failure by the board to respond within 15 business days to a written request for a detailed accounting constitutes a complete waiver of any outstanding fines of the person who requested such accounting, which are more than 30 days past due, and for which the association has not given prior written notice of the imposition of the fine. So it is important that you timely and properly respond to a request from an owner for an accounting. Interest. Assessments that are not paid when due bear interest at the rate that's set forth in your declaration or your bylaws. But if it's silent or no rates provided, then it's 18% per year. But if your declaration or bylaws have a lower percentage, then that's the interest you can charge. Notwithstanding the declaration of bylaws, compound interest may not accrue on assessments and installments that are not paid when due. What about late fees? You can charge an administrative late fee, which cannot exceed the greater of $25 or 5% of the amount of the delinquent installment, if permitted by the declaration of bylaws. You can't charge interest on the late fees. Okay. If your documents have a lower late fee, $10 or something like that, then that's what you're limited to. But to emphasize, you cannot charge any late fee unless it's authorized, again, by your declaration or your bylaws. Now, you're also entitled to collect attorney's fees and costs incurred in collection, but we're going to talk about notice of late assessment first. And as far as how are payments applied, any payment received by an association must be applied in this manner. This is pursuant to statute. First to interest accrued, then to any late fee, again, which are authorized, then to any costs and reasonable attorney's fees, and finally to the delinquent assessment. And even though it's not on the slide, I'm going to mention, if someone tries to send you some kind of restrictive endorsement saying, for example, here's a check for, they owe you $3,000 because there's interest and late fees and attorney's fees and stuff like that in there. And they send you a check for $1,000 saying paid in full, and you cash it. And the owner tries, aha, you cashed it, paid in full, too late. You could, under the law, those restrictive endorsements are not effective. So if an owner sends in a check with a restrictive endorsement, the restrictive endorsement is not effective. But talking about attorney's fees, you cannot charge attorney's fees on a delinquent account, on a collection, unless first you send them a notice of late assessment, which complies with the form set out in the statute, which is 720.3085. Okay, that notice of late assessment will specify very specifically what they owe. You must break it down in terms of the amounts and the due dates. You have to give the owner 30 days to pay. Okay, and you can't charge attorney's fees until this notice of late assessment in compliance with the statute has been sent to the owner. Now, it's required to be sent by first-class mail to the owner at their last address as reflected in the association records. But if that is not the lot address, in other words, if their address is up north or wherever, then you also have to send it to the parcel address. So if their address, their official address is not the lot address, not the parcel address, you have to send it to whatever that address is and the lot address. Okay. There's a rebuttable presumption that it's been done correctly if the person providing that on behalf of the association signs an affidavit. So we require, when we do collections, we want to see the notice of late assessment and we want to see that affidavit as well. And they have to comply with the statute. Now, okay. Liens. This is your power to collect your assessments, quite frankly, is your authority to lien the lot. So you have a lien for all unpaid assessments, and you can file a claim of lien where the lot is located to secure all unpaid assessments, interest, late fees, and attorney's fees and costs. The board must provide the owner with not less than 45-day notice of its intent to file a claim of lien before it files lien against the parcel. This is typically what we do on behalf of our clients. When we do collections, we do that 45-day notice of intent, provided the notice of late assessment was proper and met all the requirements that we just talked about. So after the lien goes on, then what happens is another 45-day notice must be sent to the owner before that lien can be foreclosed. So there's two 45-day notices: intent to file a lien, and then after that, after the lien is recorded, then intent to foreclose. Now, what about first mortgagees or lenders? They have a limited assessment liability when they foreclose and they take title. So what the law provides is the liability of a first mortgagee or its successor or assignee who acquires a lot by foreclosure or by deed in lieu of foreclosure for unpaid assessments that became due before the mortgagee acquired title. It's limited to. So if a bank lender forecloses, they foreclose on a delinquent owner and the lender takes title because no one buys it at foreclosure, that lender is under what they call a safe harbor. So they're only entitled, or only obligated to pay the lesser of, 12 months of the past due or unpaid common expenses, or 1% of the original mortgage debt. Frequently, the 1% will be less, but when a bank, lender, whatever, takes title through foreclosure, provided they name the association as a defendant in the suit, they come within this limited liability safe harbor provision. A third-party bidder, though, let's say it goes to foreclosure sale, lender foreclosure, and, Joe Blow, Betty, Sue, Johnny, they buy that lot at the lender's foreclosure. A third-party bidder has joint and several liability for any past due assessments, okay? So they are going to be liable for the past due assessments. But if the association forecloses and takes title, and then the lender comes behind them and forecloses, a third-party bidder is not liable for assessments that came due when the association owned it. So if the association forecloses its own lien, owns it for a while, maybe you rent it, who knows? Then the lender forecloses. That period when the association owned it, okay, you're not going to recover that. Financial reporting. Right? Every year you do a financial report, okay? And typically, you either prepare it or you do it with a third party. Usually it's a third party, your accountant, typically. You have to do a financial report for the preceding year, and it has to be done within 90 days after the end of the fiscal year or annually on the date provided by the bylaws. Within 21 days after the report is completed or received from your third-party preparer, but no later than 120 days after the end of the fiscal year or another date that's set forth in the bylaws, the board must provide each owner or each member with a copy of the report or written notice that it's available upon request at no charge. There's different levels of financial reporting, okay, depending on what your annual revenues are or were, okay? If the annual revenues were less than 150,000, it's a report of cash receipts and expenditures. If the annual revenues were 150, okay, but less than 300,000, the requirement is a compilation or a compiled financial statement. If the annual revenues are at least 300,000, but less than 500,000, then it's a reviewed financial statement. But if it's $500,000 or more of revenue, then it's an audit or an audited financial statement. As of last year, regardless of your revenues, if you have 1,000 lots or more, you have to have an audit. Now, the owners, and I haven't, quite frankly, ever seen this done, but if 20% of the owners petition the board to increase the financial reporting, in other words, we don't want just the cash receipts and expenditures, or we don't want just a compilation, we want a review or an audit. If 20% of the owners petition the board for a higher financial report level, then the association must notice and hold a meeting of the members within 30 days of receiving that petition for purpose of having the owners vote to raise the level. If a majority of the total voting interest approve, then you have to prepare the higher level. And that can be a compilation, review, or audit rather than cash receipt and expenditure report. That could be a review or audit rather than a compilation, or an audit if you're otherwise required to prepare a reviewed. So again, you can go up as much as you can go up depending on where you are. A copy of that financial report must be provided again within 90 days of the meeting or the end of the fiscal year, whichever occurs later. The board must amend the budget or adopt a special assessment to pay for the financial report regardless of any provision to the contrary in the government documents. So if the owners want an audit and they vote it in, then the association must, budget or levy an assessment to pay for that. This is more typical, where the level is potentially lowered or reduced. In other words, from an audit on down, review on down, compilation, whatever. So if approved by a majority of the voting interest present at a meeting in which a quorum is obtained, you can prepare a report of cash receipts and expenditures instead of a compilation, review, or audit. A report of cash receipts and expenditures or a compilation in lieu of a review or an audit, or a report of cash receipts and expenditures, a compilation or review in lieu of an audit. So if the owners so vote, they can have a lesser financial report level done or financial report prepared than otherwise required. However, you cannot prepare a lower or reduced financial statement for consecutive fiscal years. So if it's voted or waived down to a lower level this year, then the next year you have to do the required level based on your revenue. But one statement I want to make here is, if your governing documents, though, require a certain level, i.e. an audit, then that's what you have to prepare. Notwithstanding what I just went through as far as potentially lowering it. If your documents require the audit, then that's what you have to do. I'll skip this one a little bit. I'll talk a few minutes about this, but basically, in your financial report, you have to have certain disclosures regarding whether or not you have reserves or whether you have statutory and non-statutory reserves. So you guys can read this, but basically you have to disclose to the owners that if you're not maintaining statutory reserves, or if you're maintaining, or if the statutory reserves have been waived, okay, or if you're not required to maintain statutory reserves and you're just, you have any kind of reserves that basically you want. Contracts and bids. Okay, this is pretty important. Contracts must be in writing, and I advise for all contracts to be in writing, but contracts must be in writing if it cannot be fully performed within 1 year for the purchase or lease of materials and equipment, and if it is a service type contract. So those contracts must be in writing. Again, I advise all contracts be in writing. All written contracts entered into by the association for the operation, maintenance, or management of the association property serving the owners should specify. By the way, the only contract I sometimes advise not to be in writing is an employment contract, but that's an issue for another seminar. But all written contracts entered into by the association for the operation, maintenance, or management of the association property or property serving the owner should specify the obligations of the party contracting to provide the maintenance or management, the cost to be incurred for each of the services, the frequency that each service will be performed, and the minimum number of personnel to be employed for the purpose of providing the services. Again, these are not statutory mandates. These are things that we advise as a business practice that you should do for what's in the contract. Bidding. If, again, pursuant to statute, if the aggregated cost of the contract is more than 10% of the total annual budget, including reserves, if any, you must obtain competitive bids for materials, equipment, or services. By the way, it doesn't mean you can't get bids for stuff that's not more than 10%. I advise for any project of any significance to get bids, but you must get bids if the cost is more than 10% of your budget. You're not required to accept the lowest bid at all. You're not required to get bids if it's an emergency. Again, a bona fide emergency, not a, made up emergency. You're not required to get bids if the association, if there's only one business entity which you can get that product or service from in the county serving association. So if there's only one provider in the county of this thing or service or item, you don't have to get bids. Contracts executed before October 1st of 2004 and a renewal thereof are not subject to the competitive bid requirements. Okay, that's over 20 years ago now, but still in the law. The following contracts are exempt from the bidding requirements. Again, exempt doesn't mean you can't, but you don't have to. Employees, attorneys, accountants, architects, management, community association manager. If by competitive bid, it may be made up to 3 years. Engineers and landscape architects. But all these must be in writing, but you don't have to be bid. Estoppel, excuse me, estoppel certificates, very important. When a unit is being sold or transferred, typically you will be requested for an estoppel certificate, which concerns information about that lot, particularly regarding assessments, but other things too. So within 10 business days of receiving a written or electronic request for an estoppel certificate from an owner or a mortgagee or either of their designees, you must issue an estoppel certificate. You must designate on your website a person or entity with a street or email address for receipt of these requests. Okay. An estoppel certificate must be completed by a board member, authorized agent, or authorized representative of the association, including any authorized agent, representative, or employee of your management company. Estoppel certificates must be provided by hand delivery, regular mail, or email on the date of issuance. Interestingly enough, not by facsimile. So they must be issued by hand delivery, regular mail, or email. They must be signed by an officer or authorized agent of the association. What goes in there? The date of issuance, the name of the owner as reflected in the books and records of the association, the property designation and address, the parking or garage space number, if any, as reflected in the books and records of the association. If this particular lot is in collections, okay, then you have to have the attorney's name and contact information if that account has been turned over to the attorney for collection. You have to include the fee for the preparation and delivery of this certificate and the name of the requesting party. Here's the real meat of the stop certificate: assessment information. The amount of the regular periodic assessment levied against the property and the frequency. So in other words, what is the monthly or the quarterly assessment? Date that the regular periodic assessment is paid through. So, date of the next installment of the regular periodic assessment that is due and the amount. So what's coming up next month, next quarter, whatever. Itemized list of all assessments, special assessments, and other monies owed on the date of issuance to the association by the owner for this specific property. Itemized list of any additional assessments, special assessments, and other monies that are scheduled to become due for each day after the date of issuance for the effective period of the estoppel certificate. In calculating the amounts that are scheduled to become due, the association may assume that any delinquent amounts that will remain delinquent during the effective period. Very important that you get the amount due and the amount delinquent and what's coming due correct. You also have to include whether there's a capital contribution fee, resale fee, transfer fee, or other fee due, and if so, the type, the amount of the fee. And this is important too, whether there was any open violation of a rule or regulation noticed previously to the owner of the property in the official records. So if this lot's in violation of something, architectural control violation, perhaps, maybe it's not painted the right color or whatever, and you've written to that owner and you don't include in your estoppel notice about that open violation, then you probably are not going to be able to enforce that against the next owner, because you're going to say, hey, you didn't tell me. Okay, so you've waived it. Just like with the assessment issue, if you don't tell them what's delinquent, you can't collect it from the next owner. Whether the rules and regulations of the association applicable to the property being transferred require board approval, and whether or not the board has approved the transfer. Is there any right of first refusal, which is pretty unusual for an HOA, but if there's a right of first refusal provided to the members or the association, and if so, has it been exercised? A list and contact information for all other associations for which the owner is a member. So if there's a master association that the owners are also required to be members of, that has to be noticed and included in the estoppel. And contact information for all insurance maintained by the association. That's usually the name, address, email, phone of your insurance agent. Now, about the fee. If the unit is current, if the lot is current, and in other words, it's not delinquent, you can charge $250 or up to $250 for the estoppel. If the lot is delinquent, you can add on $150, okay, to the estoppel fee. If they want it on an expedited basis, like, yeah, this closing is right away, we need this thing immediately, okay, if you issue it within 3 business days after the request, and it's been requested, to be done on an expedited basis, you can add another $100 to the estoppel fee. In order to charge a fee for the estoppel certificate, the authority to do so must be established by a written resolution adopted by the board or provided by a written management, bookkeeping, or maintenance contract. What about late delivery? If the association fails to deliver the estoppel certificate within 10 business days, then you can't charge your fee. So in essence, a late delivery or a late issuance means you can't collect the fee. If it's requested in conjunction with the sale or mortgage of a property, but the closing does not occur, and no later than 30 days after the closing date for which it was sought, the preparer receives a written request, accompanied by reasonable documentation, the sale did not occur, then the fee must be refunded within 30 days after receipt of the request. This is important too. Estoppel certificates are delivered by hand delivery or email. They're effective for 30 days. If you remember a few slides back, we said that you had to include in the estoppel assessments that are coming up or that are that are coming due during the effective period. Well, this is the effective period. So if it's a hand-delivered or emailed estoppel, it's effective for 30 days. If it's sent by regular mail, take into account for that, then it's effective for 35 days. If there's an oops, and if the estoppel has an error, okay, you can issue an amended estoppel, okay, if the closing hasn't occurred yet. Okay, you can't charge for that, can't charge for the amended estoppel, but it will have an effective date, based on how it's been issued. So either 30 or 35 days. And super important, at the bottom of this slide in red, an association waives the right to collect any monies owed in excess of the amount specified in the estoppel certificate from any person who in good faith relies upon it and upon the person's successor assigned. So if the estoppel certificate is wrong and the association forgot or did not include, let's say, a delinquent special assessment or regular assessment that was due and did not include in the estoppel, it will not be collectible. You've waived it. Or any other, monies. So you got to be, very accurate and careful that you capture everything that's owed to the association in these estoppels. Covenant enforcement. Okay. You have to uniformly enforce, or you're responsible to uniformly enforce your governing documents. That includes your covenants, restrictions, and rules. This anything like a type of architectural standards, pet restrictions, leasing, parking, whatever. Whatever the restrictions cover, whatever the rules cover. The failure to consistently enforce them means that you're be subject to selective enforcement or potential waiver of the enforceability of whatever that restriction or rule was that you did not consistently enforce. First thing you should do, we advise you to do is, you send the owner a letter of a notice of violation, explaining what the violation is and indicating with specificity what provision or provisions of the documents, rules, covenants are being violated. If the person does not comply, so you don't get voluntary compliance, what are your remedies? Well, there's fining, suspension of use rights, suspension of voting rights, if it's a monetary delinquency, self-help, if your documents authorize you to go and, cure the violation yourselves. And there's mandatory pre-suit mediation, and finally litigation after pre-suit mediation. What about fining and suspending? Okay. For non-monetary violations, so for non-monetary issues like, violations of architectural control or use or other things like that, you have the right to fine and suspend, okay? But you have to jump through certain hoops to order to fine an owner or suspend their use rights. First, the board imposes or levies the fine or suspension at a board meeting, okay? Then you send the violating party a 14-day written notice, at least 14-day written notice of a hearing on the violation. That notice must describe the violation, the action required to cure the violation, if it's curable, okay, and the date and location of the hearing and access information if the hearing is going to be held by telephone or other remote means. The hearing must be held within 90 days after the hearing notice. The committee that's going to conduct the hearing must be at least 3 people or 3 members appointed by the board, and they cannot be officers, directors, or employees of the association, or the spouse, parent, child, brother, or sister of an officer, director, or employee. And the role of the committee is very specific. It's very limited. They have to determine by majority vote whether to confirm or reject the fine or use right suspension levied by the board. If the committee does not confirm it, okay, or affirm it, it cannot be imposed. The committee may hold the hearing by telephone or electronic means, and an owner has a right to attend by telephone or other electronic means. By the way, the committee can't change the fine. It can't change the suspension. It can only affirm it or reject it. So it doesn't impose a different fine or a different suspension. It's either thumbs up or thumbs down on what the board has imposed after the hearing. Within 7 days of the hearing, the committee must mail or email written notice to the violating party of their findings related to the violation, including fines or suspensions that the committee approved or rejected, and how the violation can be cured, again, if applicable, and the date by which the fine must be paid. If the violation has been cured before the hearing or in the manner specified in the hearing notice or notice of the committee's filings, then the fine's not imposed. So the owner does get an opportunity, before the hearing and even after the hearing to cure it. If a violation is not cured and the fine levied by the board is approved by the committee by a majority vote, then the committee must set a date by which the fine must be paid, and that date must be at least 30 days after the notice of the findings of the committee. Attorney's fees and costs may not be awarded against the owner based on actions taken by the board before the date set for the fine to be paid. If a violation of the fine levied by the board is approved by the committee and the violation is not cured or the fine is not paid per the notice of the committee's findings, then a reasonable attorney's fees and costs may be awarded to the association. A fine cannot exceed $100 per violation unless otherwise provided in the governing documents. By the way, in condominiums, it's $100 period. You can't go above that by your governing documents. But in HOA, your governing documents can require or can allow or impose fines over $100 per violation. And they can be levied on the basis of each day of a continuing violation, but may not exceed $1,000 in the aggregate per violation, again, unless provided otherwise by the governing document. So in an HOA, you can go over the $1,000 limit for a continuing violation if your documents so allow. Also, a fine of $1,000 or more may become a lien against the lot and collected through the lien foreclosure process if the documents allow you to do so. Another difference with condominium associations, they cannot lien for fines at all. But in HOA, you can for a fine of $1,000 or more, assuming it was properly imposed, if your documents authorize liening for the fine. How about suspensions? A suspension of the right to use the common areas and facilities does not apply to certain things. You cannot suspend a right to use common areas in order to access your lot. You cannot suspend utility services to the lot, and you cannot prohibit an owner or tenant from having vehicular or pedestrian ingress and egress to and from the lot. Okay, and you also can prohibit the right to park or suspend the right to park. A suspension applies to the member and, when appropriate, to the member's tenants, guests, and invitees, even if the violation resulting in the suspension arose from less than all of multiple lots or parcels that owner may own. Notwithstanding any provisions to the contrary in the governing documents, a homeowner association may not levy a fine for the following. This is all new. So you can't fine someone for leaving their garbage can or their garbage receptacle at the curb or the end of the driveway within 24 hours before or after the designated collection date or time. And you can't fine them or suspend them for leaving holiday decorations or lights on a structure or other improvement longer than indicated in the documents, unless the decorations or lights are left up for longer than 1 week, after the association provides written notice of the violation. Use right suspensions. You can also suspend use rights for non-monetary violations. You can suspend use rights. You can also suspend use rights for failing to pay monetary obligations if the owner is more than 90 days delinquent. So you can suspend an owner's use rights regarding the common area facilities if they're more than 90 days delinquent in any monetary obligation, not just assessments, through board action, so you don't need the committee here, at a properly noticed board meeting. For the suspension to take effect, written notice of the suspension must be mailed, hand-delivered, or emailed. And that, again, requires written consent for an email notice to the owner, and if applicable, to the occupant, licensee, or invitee of the owner's lot. A suspension of the right to use the common area facilities does not apply to that portion of the common areas used to provide access or utility services to the lot, and cannot prohibit an owner or tenant from having vehicular and pedestrian ingress and egress to and from the lot, including but not limited the right to park, what we've talked about before. A suspension applies to a member and the members' tenants, guests, invitees, even if they own multiple lots. And in this instance, the suspension ends upon the payment or the full payment of the delinquency. Okay. Next, we're going to talk about mandatory pre-suit mediation. So despite and notwithstanding the fining and the suspension, if you want to sue an owner to enforce the documents, in other words, to compel them to paint the house the right color or compel them to do something or to stop doing something, okay, it's subject to pre-suit mediation. So what's subject to pre-suit mediation before you can sue? These bullet points. If the dispute concerns use or changes to the parcel of the common area, amendments to the association documents, meetings of the board and the committees appointed to the board, membership meetings, not including election meetings, because election meetings are done through the division, what we mentioned before, access to official records and covenant enforcement. All that stuff is subject to pre-suit mediation before litigation. Disputes that are not subject to pre-suit mediation, in other words, you can go right to court, collections of assessments, fines, whatever. An action to enforce a prior mediation settlement, okay? Eviction or removal of a tenant or occupant from a parcel, assuming you have that authority. Alleged breach of fiduciary duty by a board member. And recall and election disputes, which is before the division. So what is the procedure? So the procedure is that before you can actually go to court to enforce covenant violation, the ones that are subject to this, first you have to send them a statutory offer of pre-suit mediation. That letter or that offer must comply with the form of it set forth in section 720.311. And it basically sets forth the form of the pre-suit mediation demand, okay? You have to include a list of 5 certified mediators. Then the responding party, and that can either be the owner or the association, depending who has the, who's moving, who thinks the other is in violation. The responding party is required to select at least one mediator from that list of 5 mediators that's acceptable, and then respond to the offer of pre-suit mediation, demand for pre-suit mediation within 20 days from the date that it's mailed, with a copy by regular mail to the address. So you basically have to respond within 20 days of the date of the demand for pre-suit mediation by choosing the mediator and agreeing to go to mediation. The mediation must be scheduled at a mutually convenient date and time and must take place within 90 days of the date of the written demand for mediation, unless the parties agree to extend it. The parties are required to share the cost of the pre-suit mediation equally, including the mediator's fees, again, unless they otherwise agree. The mediator may require advance payment of those fees. The pre-suit mediation and pre-suit are privileged and confidential, just like a court-ordered mediation. So anything that's said during that mediation is confidential and is not admissible in court. Persons who are not parties to the dispute cannot attend the pre-suit mediation without the consent of all parties, except for counsel to each party and a corporate representative designated by the association. When mediation is attended by a quorum of the board, that's not subject to notice and open meeting requirements. An impasse entitles a party to proceed in court. So in other words, you have a mediation. Mediation is not arbitration, okay? Arbitration means the arbitrator is going to make a decision. Mediation is the parties are trying to, in essence, settle. And the mediator is trying to negotiate the settlement. But if the parties don't settle or don't resolve the dispute, then it's an impasse. So how is there an impasse? An impasse occurs when any party fails to respond to a demand or a response. Any party fails to agree upon mediator. The party fails to make the payment that required to pay the mediator. Any party fails to appear at the scheduled mediation without the approval of the mediator, or the mediation cannot be scheduled and conducted within 90 days after the demand was filed, unless both parties agree to extend the deadline. Attorney's fees, by the way, prevailing party attorney's fees. So a lot of people I talk to, they seem to make an assumption that any litigation, anytime you're in court, prevailing party gets their fees. That is absolutely not true. You're only entitled to recover attorney's fees if authorized by statute or by a contract. Which is one reason why you sign contracts. If you want to be able to recover your fees, if there's a dispute regarding the contract has to provide for the recovery of attorney's fees. In the event a person who fails or refuses to participate in the pre-suit mediation prevails, then he or she cannot recover attorney's fees. So the penalty, okay, for not participating in the pre-suit mediation is if the matter ends up in litigation and you win, but you refuse to go to mediation, then you're not going to be able to recover your attorney's fees, even though you were the prevailing party in the litigation. If a dispute is not resolved at pre-suit mediation, then the prevailing party in any subsequent arbitration or litigation proceeding is entitled to seek recovery of all costs of attorney's fees incurred in both the pre-suit mediation and in the litigation. Okay. If the dispute was settled at pre-suit mediation, but an action seeking enforcement is sought, the prevailing party in any subsequent arbitration or litigation proceeding is entitled to seek recovery of all costs of attorney's fees. So if you go to pre-suit mediation and you actually do settle, and you enter into a mediation agreement, that agreement itself is enforceable in court, and the prevailing party in that is entitled to their fees. Self-help versus injunctive relief. Okay, some documents, actually many documents, may provide or do provide the association with the authority to enter an owner's lot to correct a violation and to charge the costs incurred to the owner to make the correction. That's what we refer to as self-help. If your documents have a self-help authority, then under current or recent appellate case law, you must at least attempt the self-help regardless of any potential risk before filing a lawsuit. So if your documents authorize the association to correct a violation by self-help, you have to at least attempt that before you pursue litigation. Why is that the case? Because typically you're seeking injunctive relief, okay? Injunctive relief is a remedy in equity, which requires that there be no adequate remedy at law. If an association's declaration provides for self-help, that is considered a remedy at law. So you have to try that at least first before you proceed with pre-suit mediation and litigation, if necessary. Okay.
Yes, that
I have reached the end. I know it went a little long. It's a long presentation.
how's your voice? Your voice, you sound like you made it through. What I'm going to do, folks,
Thank
is
you, everybody.
yes, and I didn't realize I didn't have my firm background there. Let me do that real quick. All right, so um, we placed the evaluation link into the chat a few times already, and what I'm going to do is, since we did go over, I'm going to enable the Q&A now, but Peter's only going to answer a couple of them because we are over. The required part is over. After you fill out the evaluation, you can go. But
How many-
if
Are there
Go ahead,
tons
Peter.
of questions? Oh, go
What was
ahead.
that, sir?
Are there tons of questions?
No, I haven't. We just enabled the Q&A. Just pick a couple. If anybody has any, just answer two or three, and that's it. We're already
I
over.
apologize by all those on the listening, watching.
No,
Yeah, we didn't get to all the questions. People always say there wasn't enough time for questions. It's tough in this format. It just
the required part is the important part is getting everybody
yes, you got certified.
which is what we did. Camille, what is not working? I have several who attended it, who submitted it, and it's working fine. You might be missing a required field. So Peter's going to go
All
over.
right, I see the questions coming up now.
Yeah, do a couple, and then I'm going to share the screen.
Let's see. Blah, 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 blah. This is all preliminary stuff. Hang on.
Okay.
Can the meeting notices? One question was, can meeting notices be posted in the community instead of mail, deliver, electronic? No. I mean, depends on what kind of meeting it is. Okay. Certain meetings, like board meetings, you're only required to post, okay, 48-hour notice. Membership meetings, you have to transmit those to the owners. Certain board meetings must also be transmitted to the owners as well as posted. So you can't skip transmitting to the owners when you have to. Let's see. A lot of
Dave,
these,
oh, go ahead, Peter.
no, a lot of these are just still procedural stuff. Let's see.
Oh, are you looking in the
There we
Q&A
go.
or the chat?
No, I got, unfortunately in the chat. Hang on, sorry. My bad.
Yeah, folks, do not ask your Peter questions in the
All
chat.
right.
Please use
Now
the
I'm in,
Q&A.
now I'm in Q&A.
Yeah.
I already answered one of them. Okay. Coffin language. How would you know if you have coffin language? Basically, your best way, and again, not shilling for lawyers, if unsure, have your attorney review your documents to tell you whether or not you have coffin language. Managers are not allowed to give legal advice. I would say that is legal advice, okay? And should be, you know, I would rather have my attorney advise me on that issue than have a manager. I'm not dissing on managers. I'm just saying, uh, I'm sure a lot of them are capable of answering the question, but you're better off, having the attorney answer that. Does any services exceeding 10% of budget have no, does any services exceeding 10% of budget have to go out? Okay, this is a question about bids. Basically, other than the services that are excluded, like landscape architect, attorney, accountant, management, the other ones I mentioned, all other services that exceed 10%, yes, must be put out to bid. Only those that are expressly excluded are exempt. Board of directors meeting to discuss day-to-day community issues. I guess that means you have to have in my view, the way the law reads is anytime a quorum or more of the board meets to conduct association business, that's a board meeting. What does that really mean? Who knows? Okay. It's sort of like obscenity. You kind of know it when you see it. If you're going to be doing any kind of, in my view, substantive discussions about association things, even if you're not taking the votes and you have a quorum or more, that's a board meeting. I look at it pretty conservatively. Okay. Board ratifications. I'll skip that one.
And folks, I'm just testing the evaluation form. I have over 50 of you that have already submitted, so it looks like it's working. So folks, if you're having trouble, you might be missing one of the required fields. Just check out where the asterisks are and make sure you have stuff filled in there. Peter, back to you.
Here's a question. Since we have a property management company, aren't they responsible to make sure we are doing things correctly and legally? Uh, yes and no. I mean, again, they do their management duties. They are not your legal counsel. Uh, they are, unless they're not. I would say, if you put a gun on my head, I would say no. Okay. That although they do advise you and they help manage you, they're not attorneys. They can't conduct unlicensed practice of law, and they don't advise the association on legal matters. They're not permitted to. Do members need to disclose that they own several houses in the neighborhood prior to being elected to the board? No. I've never heard that.
Hmm.
Can board members profit from neighbors from their business with ARC Connect? Well, we talked about conflict of interest, okay? If it appears to be a conflict of interest, then it has to be disclosed and properly approved. That question has a lot of angles to it.
Just do a couple more. Just do
Do
two more.
HOAs have any obligation to suspend rules for residents who travel back to their home country for months at a time? We have a resident who leaves for 6 to 8 weeks and gets upset when they get notices about violations. No, there's no suspension of the clock when someone's away. Okay. You don't get a pass for being out of the country. What rule
That-
precludes having more than 3 board members? Therefore, is it a Well, the rules are a quorum or more. A quorum is a majority, so whether you have a quorum of board members depends upon the size of your board. Can we request all finance documents from the HOA, such as bank statements? The answer to that is yes. This is Gustavo. Uh, Basically, all the financial records are available. In fact, contrary to some popular belief, even the individual owner's account information, like whether they're delinquent or not, that's available to any owner upon request. Now, not personal identification information like social security numbers, bank account numbers, all that kind of stuff. That's not accessible, but financial documents, otherwise, financial information, yes. Are homeowners who rent their homes to tenants obligated to provide leases and contact information for those residents? Only if the documents require. That's not a statutory item. That's purely driven by your documents.
All right, pick one more, and then I'm going to take over and go over the evaluation for those who are still here.
What if you can't find three people to be on the finding committee? Can the board still levy fines? I get this question a lot. The answer is no. Okay. You have to be able to fulfill or fill that committee because they have a vital role in order to fine or suspend.
And then there was one rogue question in the chat from Debbie. Is there a term limit for a director being on the board in an HOA?
Yeah.
There you go. Nope.